Good evening. For those of you in the audience who have not attended one of these hearings recently, let me review our normal procedure. Staff will introduce each item for consideration. If you'd like to speak, please fill out the speaker form located on the table in the lobby and indicate the item number and whether you are for or against the item, and please give the form to the clerk seated on my left. The applicant and supporters will be heard first, then those in opposition to the request will be heard next, then the applicant may be given a chance for rebuttal if necessary. Comments should be restricted to pertinent information regarding the agenda item under discussion. If you're an individual, you will have 3 minutes for comments. If you're speaking on behalf of a group, you will have 6 minutes for comments. Speakers should move closer to the podium when their item is being presented by staff. Speakers should identify themselves clearly for the record by stating their name and address. Each speaker should be given respectful and courteous attention. The board may ask questions of speakers or staff members. Information such as pictures, site plans, letters, etc. presented at a public hearing will be kept as part of the public record. If you have something on your cell phone you'd like to show us, we'd love to see it, but you have to promise to send it to staff after the hearing, otherwise they have to keep your cell phone. You probably don't want to give it to the county. Your choice. I will then ask for a motion from the board. Once a motion has been made and seconded, discussion will be closed to the floor. Following board discussion, a vote will be taken. During voting, board members who do not cast objecting votes are considered to have voted in support of the motion. Any person aggrieved by any decision of the Board of Adjustment may, within 15 days, file an appeal to the Board of County Commissioners to the Planning and Development Division of the Development Services Department. Okay, we're ready for our first item.
Good evening. For the record, Mary Moskowitz, Planning and Development Services Division Manager. Item 1 is an appeal of the planning manager's determination of a setback to the vertical plane. On February 2nd, 2023, I responded to an inquiry to the Seminole County Attorney's Office regarding building permit 20-9800 regarding how setbacks are measured. My interpretation of the Land Development Code, Section 30.1343, is that the setback shall be measured from the first vertical plane. In the specific case related to this question, the vertical plane would be measured from the posts that supported the roof line. Building permit 20-9808 was issued as an internal revision to an existing pool house. Since it was an internal revision, it was not routed to the zoning reviewer for review. During a site inspection, the building inspector noted that the internal revisions went beyond the scope of the original permit. The revisions required the submittal of a revised building permit. The revised building permit was noted as an addition. Thus, it was routed to the zoning reviewer for review. The zoning reviewer requested a site plan to indicate the setbacks. After request for a legible site plan, the applicant was offered the option to redesign the addition to meet setbacks or to apply for a variance. The applicant requested a definition of how the setbacks were measured. Upon receipt of the inquiry, I provided the determination. Again, the applicant was offered the option of applying for a variance, or if he disagreed with that interpretation, the ability to appeal my determination to the Board of Adjustments. As the board is aware, a variance is determined by the specific circumstances of a particular parcel. In your findings, one of the findings that you make is that the granting of the variance is to the special conditions or circumstances exist which are particular to the land or structure or building and are not applicable to other lands in the same zoning district. In other words, by granting a variance, you are not setting a precedent. However, if a planning manager's determination is overturned, this new determination would have to apply to all properties. Staff is recommending that the Board of Adjustment uphold the planning manager's determination of the measurement of the setback. I'm available to answer any of your questions. Thank you.
Do we have any questions? Oh,
Thank you.
simple. Thank you. Is there anyone else to speak on behalf of the county? Okay, is anyone to speak in opposition? Come on down.
Thank you.
Just want to make sure I give everybody a chance.
No problem. My name is Douglas Gartlaub. I'm here on behalf of the applicant, the Shaws. I'm with the firm of Burr and Foreman. Also present to speak on behalf of the applicant, or we would call them as witnesses to provide testimony depending on the board's preference, are Paul Medley, the architect, Dr. Ronald Shaw, the owner, one of Mr. Shaw's neighbors, Curtis Sheffield, and in the back of the room, and he has a back brace, so standing is a little difficult for him, is Roger Haynes, the license holder for R.L. Haynes Construction, who constructed the project. There is a PowerPoint. Do I just tell you to advance it? Okay.
Yes.
Okay. First of all, with all due respect to Mrs. Markowitz, I'll take issue with why we're here today. If we can go to the first. Okay. There's two issues here. Basically, first is an ADU issue, which isn't even mentioned here. Okay. The project has been given, this project, which started back in 2020, approximately in August, was originally submitted as a renovation, which I think it's interesting that that's brought up here today. I have both Mr. Haynes to testify as the permitting party and the architect, because at no time is anything in their ordinances, and I asked this when we had our meeting to try and resolve this, say anything about missing zoning review. Okay? So if there's an internal policy of skipping zoning review, that's on them, not on us. There's an ordinance in play here, 40.71, that specifically requires that all zoning decisions must be made prior to issuance of the permit. Okay? No, this was submitted back then. Putting aside the setback for a second, the zoning, because there's an argument that perhaps that didn't come up till later, the ADU, no mention is made of it. And in fact, if you look at the plans which are attached to my letter of appeal, and I have copies of that if the board wants to see it. I wasn't clear based on the materials you were given. You were given my letter, but not necessarily the attachments. That has the plans. This isn't an ADU. We didn't file the affidavit for an ADU. We didn't request ADU zoning. So the idea that this is being held up and they're attempting to make us comply with the ADU requirement is ridiculous. Okay? And also, again, if that was the zoning and the decision they wanted, they needed to bring it up at the beginning, not at the end. If we can go to the next. Okay, this is the statute we're talking, the ordinance we're talking about. This is a Seminole County ordinance. All work done pursuant here to conform to setbacks and other zoning requirements, and no permit shall be issued to any installation which does not or will not comply with said requirements. This is a Seminole County responsibility. Mr. Haynes will testify he's permitted hundreds of buildings in his career. He would never, for a client, misrepresent anything regarding this. So there was no effort to avoid zoning as they seem to imply. Okay? Second, if we can go to the next one. Simple compliance with section 471 would have prevented where we are now, which is we're at CO. This building is built. That's when they raised this. This representation here that we applied for something and they brought this up is wrong, and it's simply not true or supported by the record. They didn't bring this up until CO and a request for an additional meter because it required additional power. That's when this gets brought up. The building is done. So they have held up the CO for 2 years based on this erroneous ADU issue and the setback issue, which they created. Okay, Seminole County Planning first raises it in October of 2021, almost over a year after the first permit is applied for. Okay, and this says it's not raised in 3 prior submissions. It's actually 4 if we think about it. Can we go to the next one? The ADU issue, the ADU ordinance came into effect in 1972. There was a structure on this property since prior to the ADU ordinance as a pool house. When Mr. Shaw bought it, him and his wife bought it in 1987, they combined that structure with the house. This is not a detached structure. okay? This is not an auxiliary dwelling unit. There's no intent to rent it. So the idea that an ADU designation has been placed on it and a request to comply with that is being made to hold up CO is ridiculous. But they don't say it at the beginning. One, when he does the original renovation, they don't say it, 1987. He applies in August of 2020, they don't say it. A couple months later, it turns out that the foundation of the property is fine, but the stem wall has deteriorated to the point that it needs to be replaced. An amended permit is filed with all the new structural stuff. Do they raise it then? The ADU or the setback? No, they do not. Okay? Then after construction, we are in February of 2021. This is the third submittal, so I don't know what the submittal they're talking about is. In February of 2021, the issue was raised by the building inspector that there was a cantilevered roof that at great expense was put on the building, okay, that extends substantially out. They had to fly in steel beams at substantial cost to create a long overhang, okay? Despite the fact that the architect is here to testify that they don't need it, the inspector on site says to them, I'm not allowing this to proceed unless you put 2 columns in to hold that cantilevered steel beam roof up. As Mr. Haynes will testify and the architect will testify, they're not in the practice of fighting with building officials who say they want something to allow construction to go forward. It's re-permitted and it's resubmitted again those drawings are in the documents I submitted, and I'm happy to provide them again to this board, called out in red bubbles to show the changes. We pull out the columns, and the columns are what's causing the setback issue you just heard today, because they now, and for the first time in her opinion, want to consider those columns the first vertical plane. Okay, let's go to the next one. That becomes significant, and we'll get to that in a second, because the first vertical plane is where you measure setbacks from. Okay, up until they made us put the columns in, it would have been the house, which didn't cause a setback issue. So when they make you put these columns in, we resubmit. Keep in mind, we resubmit, do all the columns, full permitting, full comments. No mention of the ADU issue or the setbacks yet. Okay? So we build it how they've asked. Then we proceed forward. Go on. Okay, go on to the next one. Okay, one of the doctrines that we're going to talk about here, and that's why I keep going over the different steps, is the doctrine of estoppel or vested rights, which is basically the idea that you can't do a gotcha, okay? As it says, stripped of its legal jargon, which attorneys and judges obfuscate, is the theory of estoppel, which amounts to nothing more than the application of a rule of fair play. One party will not be permitted to invite another onto the welcome mat and then be permitted to snatch it away. So once a zoning determination is made, and here the zoning determination is none, there's no issue. That's what 40.71 says. They can't come back and snatch away that approval of these plans and say, now there's a zoning issue in the 11th hour. Why is that? Because once you built $700,000 worth of addition and spent years constructing it, you vested your rights, you've spent the money, you've detrimentally relied on the representation of Seminole County that this is the plans that they've approved. This is not a case where we built something other than what they approved. Everything on that site was approved, permitted, and comments submitted without any of these issues being raised. Next one. Plain reading of Seminole County Code 30.1343, which is the one we're talking about, calls for the first vertical plane. Different counties deal with this differently. It is a viable interpretation to go with the building wall. They have decided here to go with the columns that they never mentioned to us would create this issue, and now they want to argue as a setback issue. Go to the next one. Second issue, the ADU. I would point out that Florida Statute 163.31771 is the one that controls this. There's an ordinance, a local ordinance that's based on it, but they track, okay? The important thing here is one of the very requirements of it is the applicant has to submit an affidavit which attests that the unit is rented for an affordable rate. That wasn't submitted because it's not an ADU. If he doesn't ask for the designation, he can't rent it. This isn't everything with an extra, every time, under their interpretation, anytime you put a second kitchen in, it would be an ADU. This is a summer kitchen, and my client, when he testifies, if you want to see a picture, he can show it to you. When you open those doors, it's a summer kitchen. It's 4 feet. The kitchen that's in this pool area that's attached to the house is 4 feet from the water. You're not renting this to somebody else. It's not an auxiliary dwelling unit, so that's should be a non-issue. Next one. Okay, and as we said, the original design is cantilever. That's why there's no setback issue originally. It's not till the Seminole County Building Department inspector requires the columns that this issue, the setback issue, comes up. Despite the architect's belief it was fine, they comply with his requirements, they put it in, and then it's not, contrary to what you heard here today, that's not when they raised this issue. Had they raised it in planning review, we could have addressed it. We either could have fought the issue of the columns, or we could have designed around it. But they didn't do that. We had to put in footers, columns, rebuilt it, and at that point, a decision was made to enclose the patio because we had to have columns there anyway. Go on. And then, yeah, so it's October of 2022, for the first time that we see this idea that this is an issue, that these zoning issues are here, okay? Go on to the next one. Keep in mind here, there was a comment made by Mrs. Markowitz. Oh, well, they chose not to go for a variance. Because why didn't you go for a variance? Why not? Think about that, okay? I do variance hearings all the time. Variances are applied for under 2 circumstances commonly. You've been told by the planning department at the beginning that you can't build what you want, right? Because then you go for the variance and you design to deal with the variance. Or 2, you built something you weren't supposed to. Either something got messed up in construction, or you built something, or you need to change something, it gets brought up, it gets dealt with, and then the structure gets built. Or if it's an unauthorized construction, it was not built with a representation that this was okay, so then if it has to be torn down, that's your own fault. You built it without the permit. That's not what we have here. If you say my client has to go get a variance, which is what they're telling him, he has to go to a hearing where he has to prove hardship, right? Where he has to prove all the elements of a variance. And if it's denied, the standard of review is extraordinarily difficult. And then what are you telling him? That the improvement that was permitted under the permitting authority through 3 revisions and over a year and $700,000 has to be torn down or modified. That's not what the person who's seeking a variance should not be in the position of having an approved building that needs to be torn down because they didn't get the variance. Next one. We would obviously request, therefore, that based on, there's 2 things to keep in mind. This all goes away if you just find that 40.71 required them to do this ahead of time. That, and the law is clear. You got to read that statute on its face. It's a plain reading. They haven't even addressed it. Their explanation is, oh, well, during review. That's not the case. You've got the plans in your stuff. If the issue was when the plans were February 2021, their first time they raised this is months later. when it's already built. That's not what that ordinance allowed. So this idea that somehow something new came up or something was built not in accord with the plans is absolutely false. And the architect and the license holder are here to testify to that. And the plans are in your record. So 40.71 makes it easy. Just say, done. Approve these plans. The ADU issue and the setback issue is a non-issue. Seminole County has waived that issue. Okay? Doesn't create a precedent, doesn't create anything with regard to future variances. You're set. Second issue, ADU. You can just find that the ADU isn't an ADU. Every building is not an ADU. An ADU is a right. Hey, I can rent it. If you go out there and find out that he's renting it without the ADU designation, then you fine him for a zoning violation. It's simple. There's no ADU designation needed. With regard to the setback, you can decide either that, 40.701, or you can decide that the proper reading of that statute is that these columns don't create a vertical plane, that the vertical plane is the building. Okay? Or that they created the problem by putting in the posts. This was not the design intent of the building. So anyway, I didn't know what your timeline was for applicants. If you'd like, I can. Huh?
The applicants do not have a timeline.
Okay. I'd like to bring the architect and have Mr. Haynes testify, unless you'd prefer to just ask questions, unless you wanted to question them yourselves. I've seen boards do it either way.
Well, it's the applicant's case, and I would
Okay.
it to be presented in a way that the applicant's comfortable, so.
I'd like to call Paul Medley to the stand then.
We do have a microphone there in case the
Oh,
gentleman
right.
that mentioned,
Yeah, we do need to record it, so.
Okay.
in case he can't stand up, maybe he can.
I can bring it back to him. He's talking about Mr. Haynes. You can go ahead.
Sir, state your name and address for the record.
Paul Medley, P&M Architecture, 101 Smoke Rise Boulevard, Longwood, Florida.
Okay.
Are you familiar with this project? I'll ask you questions, and then we'll move it quicker that. Are you familiar with this project?
Yes,
Okay. And have you permitted other houses like this?
yes,
Okay. Is it fair to say more than a few?
yes,
Okay. In Seminole County?
yes.
Okay. First of all, was there any design intent to make this pool house an ADU?
No, this
Is it-
was a summer kitchen.
Okay. And it just, go ahead and explain the design.
I mean, the location of the kitchen and the unit is between the house and the lake. The idea of renting, bringing in tenants and having them between your house and the lake and the dock is, I mean, 4 feet from the pool, no. This is family living space. There's not enough room for an outdoor summer kitchen. Usually we don't do outdoor summer kitchens anyway with all the equipment, but they're still under a cabana or under a roof. This is where it goes. This is where it was at before we started. This is what they used it as for the whole time they've lived there. We ended up actually opening it up more and, creating it much more connection to the pool deck. So no, this is not a rental unit in any sense of the word.
Okay.
So no.
And is it realistic, even the way the space is laid out, would it lend itself to rental?
No. See, that's just it. I mean, it's not like this is out in the front of the house where, a homeowner could rent it out. No, this is, as I said, right on the back patio, between the house and the back patio and the lake. I mean, you wouldn't put tenants in your back pool entertaining deck.
Is it unusual to put a second kitchen in houses nowadays?
No, I do it on every single high-end home will have a summer kitchen, if not multiple kitchenettes within the house itself. But summer kitchens are par for the course now.
Okay. I'm going to show you some, and does the board have, just in case you want to look at it, does the board have the attachments to the letters that were part of my, that were my appeal? Can I just make sure they get in the record? Like these are 3 copies that have the attachments, because I'm going to ask him, if you turn to about the middle of the pile, there's a section of, I just want him to identify, are those your plans?
Yes, they are.
Okay.
You have a version of that you can put on the screen?
I don't have a version of it I could put on the screen.
You put it on the overhead.
Yeah.
We have a camera.
Yeah, there we go.
The county has them on record.
Yeah, but they don't have them here, and they're not. Yeah, please.
They're in the
sorry.
building somewhere.
Okay. Paul, can you come over here and find the pages
So,
that are relevant? You can page through it.
these are these are the 2 columns that the field inspector instructed the contractor to install. Okay, look, I designed this with W12 by 26-inch steel cantilevers that came out here, okay? But you know, here's the thing. When a project's under construction, I'm already working on other drawings on the drafting board. I get a call from, not the inspector, I get a call from the job superintendent saying the inspector is insisting the columns are there. I mean, it was about a 5-minute conversation. I said, does the owner want that? Is he okay with that? And Ron was at home. He said, yeah, the owner's like, okay, whatever will keep this project moving forward without having it shut down. I'm like, fine. I will modify the drawings, because you're going to have to get them resubmitted back in to the county to show this. I said, and I will knock this out this afternoon. The next day, I had the contractor swung by my office, picked up the plans, and turned them back in. Whenever I make a change like this, it requires that I cloud it. And actually, what's not seen on this black and white drawing is that they're different colors. So there's actually a different color that clouds around it. Okay, you can kind of see the cloud here. And then there's a delta revision number that's put alongside, and then over here in the title block, under the revisions, right here, it's listed as the change. And then this gets turned back in to be reviewed.
Okay. And you got comments on this, right?
They didn't make comment, I mean,
Well,
the initial process is we do the original drawings. We submit them to the county reviews it, they come back, if they come back with comments during plan review, we make those adjustments, we put a cloud around that, and we put a delta, and we put the reason for it and the date, and then it goes back in again. If they, at that point, if there's no more comments, they approve it and they issue a building permit. During this situation, and anytime a client makes a change, or in this case, a change was directed by field inspection, Seminole County field inspection, anytime something like that is made, even whether it's the owner, whether it's the inspector, doesn't matter. That change is documented on the drawings and resubmitted back in to the county for plan review. And we did that.
okay. And did they raise this set-off issue at this time?
No, this was done, building proceed, this was during framing, by the way. So you're talking, fairly early into the project, or I'd say probably about 25% of the way into the job. This job proceeded without a hitch beyond that through multiple more inspections, apparently. I mean, I'm not out there during inspections. The contractor is, he coordinates those, but they do need more inspections all the way up through drywall. And this job went through all of that without so much as a peep from anyone. And, and then after the job is done, the finished materials are in, the drywall's in, the paint is done, everything, the appliances are installed. Then they came in, then the client came in and was doing the final certificate of occupancy. At this point is when the county brings it up, which Again, this is just highly irregular to be doing it at the bottom of the ninth inning and pulling it out and again,
Okay, can you find the page that shows that, if there is one in these drawings, I'm hoping there is, where it shows the kitchen a little better so they can see the layout?
Sure. I don't know if you've got all the drawings here.
That's what they were saying. When you sent it.
Floor plan.
Okay, floor plan's not on there.
No, wait a minute, yeah, we do. It's back here. S1, A1, A2, A3, A4. We're missing A4.
Oh, okay. So that's-
A4 has the floor plan. I can kind of show you here, this is the existing plan here.
Can you zoom in, please?
Can you zoom in? I don't know how.
No.
Okay. So this is the existing plan here. This is where the existing kitchen was at, over here. Now, I'm going to show you the framing. This ended up over here. Basically, we replaced what was there. And we opened up the wall here and here to where these corner walls just open up, and then and the pool, which is right here, the swimming pool is literally where my fingers are at. You can literally sit at the kitchen, the kitchen bar there, and the pool is from me to the laptop. That's how far the pool is. It's the summer kitchen. This is where everybody comes and entertains. The house is back here, the dock is here, out here, and the lake is here, and the pool is here. Nobody's going to put an auxiliary dwelling unit here between the main house and the lake. That's a non, if it quacks like a duck, walks like a duck,
With regard to the setback issue, with regard to the vertical plane, have you seen the vertical plane be determined from the wall when there were columns like this?
I've seen it go
Both ways?
both ways in different counties, different municipalities.
Okay.
And this is when you submit it, this is the plan review process.
Okay, so you would have expected if that was an issue during plan, it should have been brought up during plan review?
Yes.
Okay.
I mean, it's submitted into the county. From there, it gets routed wherever they route it. I don't even do the permit processing. I turn over the sealed drawings to the general contractor. The general contractor, he's the one who turns it in and processes it through. If there's any comments, they come back. They go back to him as the application representative, and then they come back through me for revisions. But anytime we make a revision during construction, or, for whatever reason, whether it's the owner or, in this case, the building inspector telling the contractor he has to do this or that, it comes back to me, and I then have to update my drawings and resubmit.
I have no further questions. If the board has any questions of Mr. Medley? Okay.
Any questions?
You can take a seat.
Should we do it? We didn't question the attorney, should we wait for?
Well, I was
should we
waiting
do
to
it?
the end. I'm making notes.
Yeah, me too.
Okay.
Okay. Mr. Haynes, why don't I go ahead and bring you a mic? You sure? Yeah.
Good evening. For the record, my name is Richard Haynes. I think he called me Roger earlier, but
Oh, sorry.
I just want to make sure it's clear on the record.
Mr. Haynes, can you, what is your position with R.L. Haynes?
I am now the board of directors, as the company's been sold and turned to an ESOP, but for all intents and purposes, I am the CEO of RLH Residential and RLH Construction.
Excuse me for one moment. What's the address? We have to get a name and address for the record.
5700.com Court, Oviedo, Florida, 32765 in Seminole County.
Thank you.
Are you the license holder?
I am the license holder, yes, sir.
Okay. Are you familiar with this project?
I am familiar with the project, yes.
Okay. Are you familiar with the permitting process in Seminole County?
I'm not a professional, but I'm very familiar with it, yes.
Okay. Is it on the contractor to point out when zoning review should occur?
Absolutely not, no, sir.
Okay. In your experience, who initiates the zoning review?
That'd be fall under the county guidelines. I mean, anytime I turn in a permit request, it's an application that's filled out. And I would like to go on record and say that I believe earlier during the testimony, someone said that it was an interior alteration. It was not known as an interior alteration, it was known as an alteration. And once you flip the plans over, you understand it's not. We're taking the whole roof off, taking walls down. But at any rate, it is not the contractor's obligation to say whether something needs a zoning review or not. That's way outside of my pay grade.
Okay. Is there anything in the Seminole County Code that you are aware of that would lead you to believe that by checking one of a number of boxes, you were somehow avoiding a zoning review?
No, absolutely not.
Okay. How many times did this go through a change in the permit?
At least 3, potentially a 4th. I'm not sure on the 4th, but at least 3. It went through the original permitting and then 2 subsequent changes.
You heard testimony earlier that during one of these permit applications, the issue of setbacks in the ADU came up. Is that true?
Only from what I heard, or
Okay.
prior testimony, yeah.
Okay. Based on your experience with this project, what phase was the project at when this was first raised?
When the concern was first raised,
Correct. When did they first, how far along was the building?
we were complete. I mean, we were done waiting on power to be installed for the project so we could fire up all the appliances and whatnot, but the project itself was done and waiting for CO.
Okay. So this was not a permit review time when they first raised these issues?
No, sir, not at all. No.
Okay. Is it your understanding that it was Seminole County's building inspector that required the addition of these columns?
I wasn't on site, but yes, I got a call from my president of the residential division asking for clarification, if you will, that an inspector asked for or required or inquired about columns to hold up cantilevered steel beams at the back. At which point I told him that that's an architect deal, we don't get involved. And quite frankly, I think I said that I cannot believe an inspector would actually put his neck on the line like that.
Yeah. Okay, so, but the beams were added at the instruction of Seminole County, correct?
The post?
Correct.
That's correct, yeah, the beams were installed per the plans, yes.
Correct. Can you explain what was done?
At the point of when the job got to that process and we were going to put the post in, at that point, we installed 2 spread footings at the back. They were piered footings. I think they were 4 or 5 foot by 5 foot. They were pretty large size footings. And then a post was put in from that to the bottom of the actual steel beam. The deck was built around it as per the plans, and the posts were wrapped. I believe the porch was screened in at some point after that.
Okay. And removal or changing that structure at this point would be substantial, correct?
Yeah, yes, it would be, yeah.
Okay. It would cost substantial time and money to the homeowner, correct?
Absolutely, yes. I mean, and the reason for that is, and I don't know if anybody lives on Lake Apopka, but these beams and these posts were flown in via helicopter. This is so far back on a piece of property, there was no way to even get a crane back there. So these were flown in over the lake on an early Saturday morning and set via helicopter. That itself was outrageously expensive. So to take it all apart and dismantle it and remove the finishes, I would imagine it would probably be 2 to 3 times that economic waste, yes.
I have no further questions. Thank you for your time.
Thank you.
Very briefly, I'd like to call Curtis Sheffield to the stand.
Good evening, sir. You state your name and address.
061 Cecilia Drive, Apopka, Florida.
Mr. Sheffield, are you familiar with the home in question?
Yes, I live next door to him to the north.
Okay, you're his neighbor?
Yes.
Okay. Do you have any objection to the dock, or the whole, the improvement as constructed?
No, not at all.
Okay. So even if a variance had been sought, you would have no objection to it?
Correct.
Okay. And you have no objection to this board deciding that no variance is needed, correct?
Correct.
Okay. I have no further questions. Yeah. I'm going to call Dr. Shaw to the stand.
I'm Ronald Shaw. I live at 3067 Cecilia Drive, Apopka, Florida, and it's my property that's under review today.
Okay. Have you been involved in the whole permitting process?
Yes,
Okay. Were you present the day that the inspector was there and required these changes?
yes, I was. I was very surprised.
Okay. And what exactly did the, as you recall, what did the inspector say?
He was out inspecting that morning, and the project was about 90% complete at that point. They were putting the decking down, and then all of a sudden the inspector says, you know, I want this cantilever, I don't like it, and I want post here. And the on-site project manager's not trying to create a fight, but he says, the architect, and it doesn't call for it. And he bluntly told him, I don't care, I want it. And they came aside and said, look, we're not in the habit of fighting with county building inspectors. After all, we do want to get this signed off. And I said, fine. So the construction of the deck and everything stopped at that moment. The call was made to Mr. Medley, and the call was being made when I walked away. And he revised the plans. It's sent to the county. As you have the record, I've seen it. It was clouded in red to show that it was done. And once that approval was obtained, those columns were put in per the county, the decking was finished, and then all of this other stuff exploded afterwards.
What phase of construction was it at that you first learned that the county was raising the setback and ADU issues?
When we asked for the certificate of occupancy at the end.
Okay. And was this in response to any permit submittal or change in the plans?
Not that I'm aware of. We were just finishing the end and needed extra power, so they were to put a meter there. And then all of a sudden, I heard about setbacks, I heard about variances, I heard about ADUs. None of these been asked or addressed or anything before. And I'd come to the county, not trying to hide anything.
Do you have any intent to rent the property?
Not likely. Not after spending that kind of money and raising my teenage kids there. No, I'm not going anywhere. I've
Okay,
lived there for
unequivocally,
35
you have
years.
no intent to rent?
No.
Okay. Okay, I have no further questions. Does the board have any questions of me? It sounded like you did.
Yes. Okay, for the sake of discussion, let's assume that the county made an error during the processing of the permits and so on, and the
Correct.
reviews and so on, okay? And I understand the doctrine of vested rights. I've tried to argue that myself on occasion. And I've also been informed by our county attorney in the past that the courts have ruled that just because the government makes an error, it's a greater injustice to compound the error, and they make people tear down buildings, including shopping malls and hotels, and because of these types of things. So how do you respond to that?
I would respond by the cases I cited to the court. There is a very well-known doctrine called equitable estoppel. It is fought over time and time again for these reasons. But one of the things the courts look at in these type of cases in weighing the equities is just what you heard them talking about in, let's see. I just want to read that again because I think it's a good quote. Stripped of its legal jargon, the theory of equitable estoppel, which is what we're talking about here, less vested rights, is a rule of fair play. One party will not be permitted to invite another onto the welcome mat and then permitted to snatch the mat away to the detriment of the party inducted or permitted to stand thereon. Citizen is entitled to rely on the insurance and commitments and statutes of the zoning authority. And that's what happened here. Okay? I mean, the fact is, what you look to in these cases of equitable estoppel to some extent is, yeah, maybe there's a mistake and, who are you going to punish? But at the same time, you have to weigh the equities, okay? And that is, in this case, who could have prevented this? The county could have. What could Dr. Shaw or R.L. Haynes or the architect have done to prevent this? Nothing. They did everything they were supposed to. This isn't just one permit submittal. This was 3 permit submittals. The very permit submittal that is causing the setback issue, right, is the very one they didn't notify us and made us install. If they had left that alone, there'd be no permit issue. So they make us install it, and now they want to say setback. That's exactly what the doctrine is there to prevent. So yes, often a simple, and a lot of times too, when you're talking, we could get into the niceties of the vested rights and equitable estoppel case law. Generally, they also look to where the representation was made, right? If it was a low-level building official that made it or something like that. In this case, this went through several levels of review. This isn't some misrepresentation by a clerk that was relied on. This is a $700,000 structure that was built in reliance on multiple, on not just a change, but multiple permit reviews. And then at the end, when CO saw it, is the first time they look at zoning? That's not our job. And I point out that this is not a mistake on the part of the county that I'm asking the court to rule in favor of. I'm asking the court to follow its own statute. Follow 40.71. The law is clear that you have to give that statute a plain reading. So anything they've now decided, because this is a matter, let's be honest, both of these are matters of interpretation. The ADU is a matter of interpretation. Mrs. Markowitz has interpreted it. The setback, matter of interpretation. This isn't a mistake. I'm asking you not to let them now come up with a brand new interpretation in the 11th hour when your own ordinance says they're not allowed to do it. They're in violation of their own ordinance. That's what they're asking you to do, to violate Seminole County Ordinance 40.71 if you uphold her ruling. So we would ask that you find that you overturn her determination that this is subject to an ADU, and we ask that you find that it is not subject to this setback. And that to the extent this was an issue, they should have raised it at the beginning. Because they deprived my client of the chance to fix it. That's fundamental fairness. And that's what government is supposed to be about. And it's not Mrs. Markowitz's job to make that determination at her level, maybe, but that's why this board is here, is to prevent when the government makes a mistake. That's why we appeal to this board, to correct that mistake. And this is a mistake. And if you go with her interpretation, it's a potentially very costly one for my client. Thank you very much.
We're not done.
Oh, go ahead.
Yeah. That was just, I have some questions
Oh, yeah,
for the
please.
planning manager, but
Please.
that's later.
I'm an attorney, I love to talk.
We'll work this way.
Bunch of questions, so bear
Sure.
with me. You cited to Florida statutes for a definition of an accessory dwelling unit.
Correct.
Is there anything in Florida law, Florida statutes, where the state of Florida has stated they are preempting the counties by that definition?
The count, just so we're
No,
clear.
no, I'm asking a question. Is there anything in Florida law?
No, in fact, what the statute says on the what they did is they passed the statute, and in fact, I have
No,
your own...
Counselor, stop. Yes or no?
No, there's no preemption, because the statute tracks.
So the county is free to define an ADU any way it wants to, right?
No, it's not free to define it any way it wants to.
I'm
It
sorry.
has to follow the statute.
They're not preempted by the state.
They are preempted to the extent they cannot conflict with the statute. What it did is empower the state to come up with an enabling statute that complied with the statute. So yes, to that extent, they are preempted.
You're not saying that in any way Seminole County's definition of an ADU is of no validity, right?
No.
What is that definition?
The definition
What is
is,
Seminole County's definition of an ADU?
I can give you if you want.
Please.
The definition is on an auxiliary dwelling unit that is intended for rental to middle and lower income housing.
Just since we have a court reporter, I want to be clear. You're saying Seminole County's Land Development Code uses the word rental in its definition of an ADU.
If I may, here is the initial paperwork. I have the initial paperwork for,
I'd like you to please cite to the Land Development Code of Seminole County and its definition of an ADU, please.
I don't have it in front of me because I didn't.
Is it your assertion, since we have a court reporter here, that the Seminole County Land Development Code, when it defines an ADU, describes rental, uses the word rental?
It uses the word rental in the sense that it requires an affidavit.
Does it use the word rental?
In the affidavit section, yes.
Anywhere else?
Off the top of my head, without having it in front of me, I don't know.
Okay. Well, first off, let's talk about the beams and columns for a moment. When the inspector went out there and said, hey, I want beams and columns on this project, was he acting beyond the scope of his authority?
No, he's the Seminole County Building Inspector. He's allowed to ask for that change.
And you didn't appeal that decision, did you?
No. we did
You
not.
went ahead and installed the columns.
I was there.
What?
I was the
As the architect, we went ahead and installed the columns, you're correct.
Right. And also, a permit being issued only means you have the ability to start building a project. It doesn't mean you're free from subsequent government review and approval, correct?
It means that once a permit is issued and the plans are provided, you are now vested in and have a vested right to those plans. You can build what's in the plans.
But it has to be consistent still with Seminole County's land development code, correct? And then engineering guidebooks and all of that stuff.
Correct.
Right.
But that's the reason for 40.71. Seminole County makes that determination at the beginning of the process. That's Seminole County's ordinance.
You answered my question. I appreciate that. And if, hypothetically, of course, we haven't discussed this
Right.
beforehand, if we uphold Ms. Moskowitz's determination, you still have the right to seek a variance, right?
Correct.
Okay. And we're all in agreement that it's not uncommon in Florida law for the courts to demand even multi-story structures to be demolished because they did not comply with the local land development code, right?
If there was a violation of the code, yes.
Okay. And you're not suggesting, because I've heard a lot of talk about how expensive this project was. There's not a suggestion to this board that because it's expensive, this applicant deserves any rights above and beyond any other citizen of Seminole County, right?
The requirements, the amount is only relevant in the sense that under the equitable estoppel doctrine, the amount of damage to the party is weighed in considering the equities. If it was a $10 change, the equities could change versus $1 million change. So in other words, when this board weighs, or a court weighs whether equitable estoppel applies, if it's a $10 damage to my client for the problem, that's a lot different when you weigh the equity and the damage to the two parties, right? than $1 million change.
But if an applicant is in the wrong, hypothetically, I'm not talking about your client, if an applicant is in the wrong, no amount of money
No.
puts him in the right.
Correct, because that's by definition, when you appeal to equity, you have to come with what's called clean hands. So if my client is in the wrong, then no, you would have unclean hands, you would not be entitled to the equitable decision in your favor. So no, you could spend $1 million, and if you're coming to the court or this panel with unclean hands, which I don't believe we are, but hypothetically, as you said, then yes, that would be a basis for denial of that request for an equitable determination.
Last question, and thank you to my colleagues for putting up with me for yammering on so long. You cited to the Town of Largo case for the welcome mat.
Correct.
Basic, we were talking about.
There's hundreds of cases,
estoppel
but
and
yeah.
all of that, yeah. It's distinguished by the Pasco County versus Tampa Development case. Are you familiar with that one?
I am.
And in that one, they talk about there must be a positive affirmative act taken by the government that the property owner relied on. In this instance, what was that positive step by the government that your client relied upon entitling him to estoppel?
Approving the permits after the zoning phase had passed at multiple points. Each time they approved those permits, they said, you can build this because my client is assumed to know the law, and so would Seminole County, and that is that each time they approved those permits with 40.71 hanging out there, the determination is that all zoning has been complied with because they should never have issued the permit.
Wait a minute, so you're telling me that you apply for a permit, you get a permit, you start building, from that point forward, zoning never enters into the equation?
So long as you don't change what's on those plans in Seminole County, yes.
So if you made a change from the original plans, zoning still applies?
At that point, when you make the change, with regard to the change, zoning would apply again.
Gotcha. Thank you,
So in
sir.
other words, like,
No, that answers. I'm fine.
Oh, sorry.
Thank you. Gentlemen?
I'm good, thank you.
Okay.
Sir?
I had two questions. To the best of your knowledge, on what basis did the building inspector, in effect, override, according to your assertion, the design choice of the architect in asking for the addition to the columns? Did he cite a particular code, portion of the Seminole County Code, or did he cite engineering judgment, or what basis did he present for that?
if you want, I mean, I can represent to you what I've been told. If you'd like to make a record of that, I'd be happy to. Yeah,
I
Mr.
was standing there. He just said it was his personal decision. He referenced nothing. He just said, I want it. End of story. I was standing there.
As the architect,
Well, if you're going to talk, I need to come up to the microphone. It has to be
Come on up,
recorded.
because I do want him to explain. There was, I mean,
and I would say that in addition to issuing the permits, this was a direction by the field inspector. And here's the thing, in this business, time is money. And if the field inspector wants to add a Simpson clip, even though it's not required by the code, my response is, as long as it doesn't, cause a problem of life safety, it's fine. And my response to Al, when he called me, I'm like, well, we need to, it's up to the owner. I mean, I don't have any objection with this, although this is designed with the cantilever built into it. I said, but I don't have any objection if the owner, I mean, he's standing out there, it's up to him. And Al's like, well, we're going to go around and around with this. If we just basically say, yes, sir, and do what the inspector is asking, the job can move forward. And I'm like, well, what does the owner say? Ron he's okay with it. He wants to do it. He's like, fine, whatever keeps the job moving forward. At that point, I said, okay, I will update the drawing right now. And I had it done later that afternoon, and it was back into the county the next day in the morning to have the permit. And it's not just, I mean, the drawing was highlighted. That change was highlighted. So if it was an issue with the county and zoning, I mean, they should have seen it be reissued with a cloud, a big red cloud around it. And it's not for me, I'm not, and I'm not gonna sit there and argue with the field inspector. I had one in Oviedo where the field inspector wanted temporary plywood signed off by the architect. Like, this is a temporary plywood for, on the door opening. That's gonna get ripped off when the door comes in. Doesn't matter. I had to write the letter and submit it. So there's a lot of real-world stuff like this that happens. I'm not going to sit and argue with him and say, fella, you don't know what you're talking about. These steel beams are designed for the cantilever. They're not. It's not an issue. Just follow my drawings. I could do that, but the next job that he shows up on, he's going to give a hard time to. So that's just the real-world politics of how a job operates. So when the inspector out in the field says this is what he wants to do, unless the owner says there's no way I'm going to do that, I have no objection. It doesn't negatively impact the design, so we'll do it. And we issued the drawings back into the county that indicated that.
And did they raise?
If I might, just, yeah, okay, sure. Yeah,
No,
sorry.
go ahead. I
Just
cede the floor temporarily.
I just want to make sure I heard you correctly. Part of your thought process in acceding to the columns was to avoid politics on a future project.
Oh, not just that, but just keeping the job
Part of it.
forward, primarily move the job forward.
Yeah.
But you know what? It's not about bucking heads with the guys that are out there trying to do their job. That's what the inspectors are trying to do. Now, I can disagree, and I can sit there and say, well, I'm the licensed professional, this and that, but you know what? That's not the best solution. If the client is okay, if the client doesn't mind extra hangers on the hurricane clips, if he doesn't mind that and the extra cost to do that, then who am I to step in and say, well, no, we're not gonna, no. And this happens all the time. The inspector will say, you know what, this may be missing on the drawings, or I feel it's missing on the drawings, so I'm gonna require it. This is normal practice, okay? And like I said, if the owner's okay with it, and he was okay with it because he was behind schedule, he wanted to move forward because we had issues with the stem wall, because he had to rebuild that, and that delayed the project. Anyway, bottom line was, when you asked also about once the permit's issued, it's not just that. Once a permit's issued, there are multiple inspections throughout the process that the job goes through and through and through. And as I said earlier, what's ridiculous about this is that the building was built, the paint was on the walls. And, and to have this issue come up now? Serious, I mean, and I say myself, the contractor, and the owner did everything by the book, everything. When there was a change, for instance, with the field inspector, it was clouded, delta, and the drawings were resubmitted. We did everything we were supposed to do. And here we are. Right.
Anything else, as long as he's up here?
Tom?
Not for him, no. Not for the architect, no. I do have another question.
Sure.
Is county legal counsel in attendance?
For the record, Paul Chibok, Acting County Attorney.
All right. I suppose I should know the answer to my question already, seeing as how these proceedings have made their way here to the Board of Adjustment. But, Counselor, in your presentation, you brought up the doctrines of estoppel, invested rights.
Correct.
Okay. Chapter 15 of the Seminole County Land Development Code goes into determinations for vested rights, the appeals process for when a property owner. That doesn't apply to this?
It's a different doctrine.
I would concur that that goes more towards application of the comprehensive plan situation. It's not applicable to this situation.
Very well. Okay, like I said, that answered my question. Thank you very much.
Okay, any other questions? Anyone?
As a final matter, I had an affidavit from the superintendent, doesn't tell you anything that you haven't already heard, but basically just talks about, it actually gives the name of the inspector, but other than that, you've heard what happened. And also, since Councilor Hathaway asked about it, I did have materials on accessory dwelling units from Seminole County when they were adopting the ordinance, and the whole section of it talks about, the whole purpose of it was to increase the rental market for lower and middle income housing. That's the reason it was allowed. That's why they...
That purpose is detailed within the Land Development Code?
It is. There is a fund, they had to make, just so you know, in order to have this, the ADU designation in your code, you have to have made a finding in your ordinance that you need lower and middle income housing. That's the reason the ADU statute was passed.
Oh, sorry. It's not my memory, but okay.
And that's the statutory finding for why the ADU thing is, why they passed the statute on it. Your ADU statute actually, I think, may have predated the Florida statute, so this may have been when you came into compliance with it. But just for the record, I'm not saying there's a violation. I'm just saying the reading of the ADU doesn't, that this isn't, it's an intent issue. There's no intent here. That's why no affidavit was filed. That's why there's an affidavit requirement. You're supposed to file an affidavit if you want an ADU. It's then tagged onto your zoning. That's the procedure. We didn't do that because this isn't an ADU. So, is there any other questions by the board?
There's a question about this, since he gave it to me and it's new testimony?
Was that?
Or am I dragging this on too much?
Well, if you have a question, ask it.
Sure.
Now's your time.
This is what you gave to me.
Correct.
And it says here, and this is citing to Chapter 2 Seminole County Land Development Code, accessory dwelling unit definition. A dwelling unit attached to, this is attached to your client's house, right?
Correct.
Or included within a principal dwelling unit, so we meet that test.
Correct.
Or located on the same lot, which it does,
Correct.
right? And having an independent means of access. Does it have that?
It has a door.
All right. And such units may include a full kitchen.
It doesn't have access to the front of the house. You have to go through the house, or I guess you walk through the side yard.
Yeah.
It doesn't have its own independent access.
But we've got an or here. So how does what your
If you
client,
turn to the back page,
no, this is the definition.
I know, that's the definition, because, but the definition has, any statute has to be read in its entirety. You don't read one section like the definition. So yes, this fits that part of the definition of an ADU, but then but it's part of an application process. You're getting a right, in other words, to build an ADU, right? To have the right for my zoning to allow me to rent a separate unit in my building, right? Which is an ADU, I need to apply for an ADU. If I don't apply for an ADU, which part of that process, if you look on the, I think it's the last page, I have to file an affidavit promising only to use it, right, for lower, middle, and income housing.
No, you keep
Otherwise,
saying right. No. Every time you say right, I'm just going to say no. That's not here.
it's at the back.
You gave this one page right here.
I realize that, but you can't read that one page in isolation.
Nothing else in here says definition. This is the definition, and you
I
gave it to us.
understand that, but the definition would then be considered if I applied for it. In other words, this is R1 zoning. He could only have a single-family residence. He can't rent anything. He can't rent a separate unit. In order to get the right to rent a separate unit on his property, he needs to qualify under the ADU, which this would if he applied for it, but he hasn't.
All right, if we look at the other things you gave me, benefits of accessory dwelling unit, that's dicta, right?
No,
Accessory
that's
dwelling,
part of the finding, but...
no, it's not. This is a Seminole County
Oh, that's
slide.
Seminole County's part, yes.
And this thing, that's just dicta 2. That's not the Land Development Code.
Okay.
And this next page, proposed regulations, that's not part of the Land Development
No,
Code, right?
this was your materials before you adopted the amendment to the ADU.
Counselor, you gave this to us
I agree with
saying
that.
this is how the county defines it, and I'm just using what you gave me. That's all I'm asking.
And I respectfully would point out that in reading any statute or any material, you have to read the whole thing.
Give me the rest.
I did. The very back page says that as part of the process, you have to fill out an affidavit, which we didn't.
No, it doesn't.
Yes, it does.
Not what I have.
Okay. If you look
All right,
at...
I'm done. I'm sorry. I'm wasting everybody's time. I'm sorry. I'm done.
Okay.
Okay, we're good.
Okay.
Is there anything else you'd like to answer?
No.
Okay, thank you. Mary, I know you've been sitting there quietly waiting. I have a question for you before you get into your rebuttal, because this is kind of what this really hinges around. What makes this an ADU?
So the zoning review at the time believed that it could be an ADU, and zoning has not approved this permit, but she asked for additional information, and she asked that they provide the gross floor area of the primary residence, because the ADU is limited to the 35% floor area of the principal dwelling unit, or 1,000 square feet, whichever is less. And then they needed to identify the off-site parking space. And she goes on to the requirements of that. And then they needed to meet the impervious space coverage. Now, she did not have enough information at the time to make a determination of whether or not it was an ADU, so she asked for that additional information. But again, as Mr. Hadaway indicated, on our definition of an ADU, it is a subordinate structure that is either attached to a principal building or is located on the same lot that has an external entrance. I believe the requirements for the rental and affordability, that is about the the impact fee waiver for affordable housing. And so those are the requirements that need to be met if you want to waive the impact fees and to be an affordable housing unit.
Okay. And in the past, and it's come before the board, and my memory serves me, I'm getting old, that we've had people want to build structures on their property, say a shed, and they want to put a kitchen in it, and they're told, no, it's not an ADU. You can't have a kitchen in a non-accessory dwelling unit. Am I correct?
So in the past, prior to the adoption of the ADU ordinance, we had a use called a guest cottage, and that did not allow for a permanent kitchen. And so, you may be old, and so if you remember some older permits that we had, those would have had that guest cottage and the prohibition on the kitchen area.
Right. And so does our ADU require that, to be an ADU, that they have to file a paper stating they're going to use it for rental purposes?
No, that's only for the impact fee waiver.
Okay, I just want to make sure I'm clear.
No, that's okay, thank you.
Okay. What do you have in rebuttal? You've been listening to everything. What would you like to say?
So again, this permit was reviewed, the revision was reviewed by our zoning reviewer. At that time, the zoning reviewer made the comments to address whether or not the setbacks were met and whether it was an ADU. We tried to cure the situation and come up with a solution that was amenable by all parties. My goal is to get compliance with the code, and so we offered the ability to apply for the variance. In terms of the accessory dwelling unit, we did do research. There had been a previous unit on the site, and we do have language in our code about non-conforming structures. And so, but if a non-conforming structure, so the unit was built prior to the adoption of our land development code, but had been permitted. Had they continued moving along and being, happy with that, they could have continued having a guest unit on the property. But because of the kitchen, we asked for the additional information to make the determination of whether or not it was an ADU. An ADU is a permitted use. They can continue having that use. If it is determined that it meets the requirements of an ADU, they would be subject to the impact fees, and I believe they were trying to get out of that requirement.
Do they have an ability to sign a piece of paper waiving their right to turn that into an ADU?
So if they do not have a kitchen, then I believe it was a 220 outlet, it would be a guest cottage. You can have multiple bedrooms in your house. That is certainly something that we see in many homes, and many guest houses have facilities that, people who don't live in the house can stay in on a temporary basis.
Any questions? Anyone? Okay, thank you.
Thank you.
Okay. Do we have a motion?
Mr. Chair?
Yes, sir.
I was going to say a few things. I'll just make the motion, and then we can have
Then
a
we can have
conversation.
some discussion.
I don't think the applicant has met his burden, and I move to affirm and uphold staff's actions.
Okay. So you moved to uphold the planning manager's decision.
Yes, sir.
Do we have a second to the motion?
I'll second.
Okay. Discussion.
I feel like, Seminole, this whole thing about rent, that's rubs me the wrong way to bring before us that. It's not an issue, it's a red herring. And I'm annoyed that we've had to have that be part of the conversation. And Seminole County has the right to define an accessory dwelling unit however it sees fit. The state of Florida has not preempted that. I think estoppel is completely inapplicable in this situation. There is this issue of the columns. The applicant chose to go ahead and erect them. And the applicant is stuck with that. They could have contested it. The applicant also does have the ability to seek a variance when this is done, so the applicant does have options. This is not the final say on this project. So considering the totality of those, I don't think there's anything here where it shows that the applicant met his burden to overturn what Ms. Moskovitz did.
Okay. Tom, do you have anything? You have anything? Larry, anything you want to add?
My concern is as it's been explained, they've gone through the process on at least 3 to 4 times, We have a professional architect that basically said he designed something, and with the calculations that were approved by the county to put up a roof line cantilever without the post. I didn't hear anything why there was any reason to put the post on. So the fact that I understand their logic in trying to move the project along, avoid delays, and just agree to put the posts in, but then they found out they were in violation of a setback. I don't see that there was any burden that they needed to prove at this point. So, not to argue with Mr. Hathaway, but, in my opinion, they have shown that they proceeded in the right manner. They were given the direction, and they moved forward based on jurisdiction and the recommendations and the requirements by the county at that point, and they followed through on every aspect of it until they were found now they were in, non-conformance with a setback. So I'm not necessarily feeling like this is an issue that can't be resolved, by making a decision on the appeal. So, thank you.
Okay.
And I will chime in at this point. Thank you, Larry. But for the intervention of the building inspector at that point to mandate the addition of the columns, which was not in the original design of the architect, this would not have become an issue. The building inspector was a duly appointed and empowered employee of Seminole County, and the architect, the contractor, and the property owner seem to be acting in good faith upon the judgment of the building inspector, however questionable it might be appearing to us at the moment. They appeared to have been acting in good faith this entire time. I agree with Larry.
Okay. I'm torn on this. I have great sympathy for the owner got to the end of the project and all of a sudden they have something that is potentially able to stop the entire project. I do think they have, as he said, other options. To me, the issue is whether or not it's an accessory dwelling unit. I'm not, personally, if it's an accessory dwelling unit, then the way the county measures it is the way the county measures it. And if we override that, then they have to go back to every decision they ever made that where they measured off a column and change it. And I don't know that that's reasonable. It's whether or not, to me, whether or not it meets the qualification as an accessory dwelling unit. And you know, when things are built, they're built for the life of the property. So he has no intention of making an accessory dwelling unit after it, but when he passes on someday, because we all want to go eventually, the next guy could, because it meets the requirements. And so then it weighs in my decision on whether or not I agree with the county that it could be an accessory dwelling unit based on the construction of it. I'm probably more willing, given the circumstances affecting the applicant, I would probably be more willing to go towards a variance, but that's not before us, because there is some hardship on him, and he didn't necessarily create it. But I don't know that I'm willing to override the county in their decision. Okay?
All right, I have a question for us.
Yes.
For us, that is. For the most part, the variance applications that come before us, when we make a decision on those, the precedent that we establish by voting yea or nay on those is very small. Usually it's limited to somebody in the same subdivision coming back a couple of months later and saying,
And
hey.
each one's supposed to be unique, so it's not
Correct.
supposed to set precedents.
That's why I said it was very small. What sort of precedent would we be creating by voting yes or no on this particular
Well, as
issue?
I understand it, if we...
Because this is different from our usual
Right.
business.
If we override their determination, and somebody can correct me if I'm wrong, if we override the planning manager's determination on how it's measured, then that changes every other one they've ever done. So it's a retroactive problem going backwards. Now, if I disagreed with their argument that was an accessory dwelling unit, I don't know if that would have that same effect. So to answer, it potentially could affect the historical decision. I don't know how many there are out there and what that would be.
And I'm all for providing relief to a property owner who feels that he's been aggrieved by the process, when he feels that he's followed the rules up to this point.
My heart breaks for them flying in a helicopter to fly columns in. I can't even imagine how expensive that was. That's crazy.
However, if the possibility exists to provide relief that would satisfy the property owner in the form of a variance, that would satisfy that and then not create the
Right,
entanglement.
But the variance is not before us. We can't-
Yes, I'm
We
aware of
have
that.
no way of messing with the variance right now.
I'm aware of that, but this is what's before us today.
Right. So we either uphold her decision or we do not. If he wants to, if we uphold her decision and he chooses to apply for a variance, he has that right.
Mr. Chairman, can I just make
Yes, ma'am.
I just want to state that the decision on whether or not this is an ADU has not been made. We've just asked for additional information. So we can still make a determination.
If you determine that it's not an ADU, then are the columns good?
We would still need a setback. So the determination was the measurement of the setback. We have not made a determination as to whether or not it is an ADU. We have requested
Okay.
additional information.
So is, even on a regular house, it would measure off the columns, not the wall?
Correct, yes.
I did not know that.
Yes. And then we also have language about nominal overhangs as well, so
Right.
that there may be information.
And that's probably, we normally see the columns are
Yeah.
pretty close to the house.
So just point of clarification on the ADU issue.
Okay. Yes, sir.
As my colleague and had mentioned, talking about staff and things, it popped something into my head. And if I could ask the county attorney's office, for purposes of an appeal like this, what deference or standard of review, or if there is one, is applicable here?
The standard of review in this situation is that it's a determination as to whether to uphold the zoning manager's decision on her interpretation of the code, based on the evidence that's presented before you, as to whether it is supportable or not supportable in her determination. So again, it would be,
Is the staff presumed correct?
that's a very good question. I would say that there is a presumption that they are acting in good faith in fulfillment of their duties. And again, it would be, it is the way, if you're looking for how to weigh this out, there should be more evidence that her determination was correct than incorrect.
I follow. Thank you.
I hope that helps.
It does.
Okay, any more discussion? All right, so we have a motion to uphold her decision. All in favor of that motion, say aye.
Aye.
All opposed?
Aye.
Okay, the motion carries 3-1, the decision's upheld. You can appeal it. I believe it's 15 days like any other decision, correct, staff? Yes, so if you want to appeal it, you can go get with staff, they'll help you do that. You might want to consider a variance request. You might find given the circumstances of this, that might be a viable option. Okay? All right. We're going to take a 10-minute recess so everybody can use the restroom.
I apologize.
Good evening. For the record, my name is Angie Gates with Planning and Development. Item number 2 is a request for a side street south setback variance from 15 feet to 7.5 feet for a fence in the PD Plan Development District in the Sterling Meadows subdivision located at 2540 Bouillon Loop. The subject property is a corner lot considered to have 2 front yards for setback purposes. The front of the house faces Bouillon Loop. The Sterling Meadows Way side is where the variance is being sought. Traffic engineering has no objection to the placement of the fence as it relates to site visibility. And the applicant has received approval from the Sterling Meadows Homeowners Association. The proposed privacy fence will be 15 feet from the sidewalk and 27.5 feet from the edge of pavement. There have not been any prior variances for the subject property, and this concludes my presentation.
Okay, any questions for staff? Okay, is the applicant present?
Yes.
Is there anything you would like to add to the staff presentation? You don't have to, but if you want to, you got to step up.
Really? Good afternoon.
Please
I'm
state-
Marcia Brown,
And state your address.
2540 Bullen Loop, Sanford. I would like this fence because I'm the first one. You come in on the left when you come in through the gate. It's a 2 street. And I'm an elderly person with a little young daughter living there. We have a pool, but the pool, it's the bugs net. And so on the street, the little corner street there, you'll find the walkway, you'll see dogs, people walking their dogs, the little children, and because it's open up, anything can happen. And I just want the protection of a fence with a gate to make sure that I'm in the right, as I'm doing here, trying to be in the right in getting my fence. That's all. Easy case.
Okay.
All right.
And why do you want the fence to extend down the side of the house? Why not
Because
stop it at the corner where the pool is?
At the corner where the pool is, because my home is the first on the left with this main street coming in, no security. And I work at nights, so I just want that enclosure to be a little bit more up, because I do need a gate, because I want to keep also my HOA laws in my lawn, in getting a lawnmower right in there to keep my lawn as well. So that's the reason why I really want it up further from the pool. It's not just for privacy. I need protection as well. And I'm just a 60-year-old lady with a little daughter, so I really need protection.
Okay.
Yeah.
Any questions for the applicant?
She wants us to leave, she's...
Okay, thank you.
Okay.
Is there anyone else to speak in support of the request?
No. Only God.
Well, he can talk as long as he wants. All right. Is there anyone to speak in opposition to the request? Do we have a motion?
Mr. Chair,
Yes, sir.
motion to approve.
You have a second?
Second.
Any discussion?
Yes, I have a question for staff.
Yes.
The application references a house at Monte Cristo Way and Klondike Place as having a similar fence setback. Do we have an approved variance on file for that house? I don't have the address.
Oh, I'm sorry. Yes, there were several variances that have been approved in that subdivision
Okay.
for the same thing.
All right. Any other discussion? All in favor of the motion, say aye.
Aye.
All opposed? Motion carries. Enjoy your fence.
Thank you.
Good luck. All right, next item.
Item number 3 is a request for 1, a side street west setback variance from 25 feet to 10 feet for a shed, wall, and garage addition, and 2, a wall height variance from 6.5 feet to 8 feet for the R1AA single-family dwelling district in the San Leandro Springs subdivision located at 1661 Carlton Street. The property is a corner lot considered to have two front yard setbacks. The front of the house faces Carlton Street, and the South Crestview Avenue side is where the variance is being sought. The shed will be 172 square feet, and the garage addition will be 933 square feet, both encroaching 15 feet into the required side street west setback. The proposed height, 8-foot wall will be encroaching 15 feet into the required side street west setback and will exceed the maximum height for a fence wall by 1.5 feet. Traffic engineering has no objection to the placement of the fence as it relates to site visibility, and this concludes my presentation.
Any questions for staff? Is the applicant present?
Yeah.
Is there anything you'd like to add to staff comments?
No.
Do we have any questions for the applicant?
I do.
Okay, sir, I need you.
Is it necessary for the applicant
he's
to come
gonna have
down?
Can we take that microphone to him, or?
Or- That'll work. We have to be able to record what he says.
Understood.
Injured my back 2 days ago, and I'm really having muscle spasms to drive here, so I really appreciate you doing that.
Sir, please state your name and address for the record.
My name is Lawrence Z. Barth, and my address is 1661 Carlton Street, Longwood, Florida.
Okay, I have one question, then we'll get to your question. Why 8.5 feet on the wall?
Why 8.5 feet?
Why so tall? You're asking for an...
Oh, the wall, well, actually, it's...
Or 8 feet.
It's going to be a lanai to the garden space between the garage and the shed. It's the way I designed it. I'm an architect.
Okay.
And since the submissions for variances don't require the drip edge of the roof line, specifically don't require it, when I was at planning, they said, well, we consider this a wall. And I said, do you want me to show the roof edge on it? And they said, no, that wasn't necessary. And they said, how high does that need to be? And I said, well, it's 8 feet because I'm going to put a shallow roof from there towards the house. So I'm kind of having a cove, if it's clear on the plan. So that's the purpose for the wall.
Okay, so it's the back wall of the structure.
Yes.
I got you.
Yeah.
Okay. Yes, sir.
All right. There is a substantial hedgerow on the western edge of your property, adjacent to Crestview Avenue. Is that going to remain?
Yes.
So the structures you intend to put in would be obscured from the street because of the hedgerow, which you're not
Right.
going to take out? Okay. Thank you.
Any other questions for the applicant? Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair,
Sir.
motion to approve.
We have a second.
Second.
Motion approved, second. Any discussion? All in favor of the motion, say aye. Aye. All opposed? Motion carries. It's approved. Good luck. And I hope your back heals. That's miserable. I know what it's like to hurt a back.
I'm going to be slow moving out of here.
Take your time. Okay, next item.
Item number 4 is a request for a rear yard setback variance from 30 feet to 20 feet for an addition in the R1 Single Family Dwelling District in the Woodlands Section 2 subdivision located at 114 Willow Tree Lane. The existing 621.13 square foot addition will be rebuilt to meet current building codes. The foundation will remain and does not meet the required rear yard setback. 5 letters of support were received from surrounding neighbors, and there have not been any prior variances for the subject property. And this concludes my presentation.
Okay, make sure I'm clear. There's a building there
Yes.
that's being reconstructed, and that's what triggered it. I got
And
you.
they have to build it to code, so that's
No,
what
I
we're
got
trying
you.
to do is come
Over a
into
certain
compliance.
percentage, and it
Yes.
triggers it. I got you. Okay, is the applicant present? Is there anything you'd like to add to staff comments? Okay, any questions for the applicant? Okay. Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Chair, motion to approve?
Second.
Motion to approve, a second. Any discussion? All in favor of the motion, say aye. Aye. All opposed? Motion carries. Good luck to you. All right, next item.
Item number 5 is a request for a side yard east setback variance from 10 feet to 2.5 feet for a boat dock addition in the R1 AAA Single Family Dwelling District in the Springs Valley Farm Section 3 subdivision located at 114 Camphor Tree Lane. The existing boat dock was built in 1969 and is approximately 552.6 square feet. The addition of the boat slip extension will be 113 square feet, making the total square feet approximately 665.6 square feet, and will encroach the side yard east setback 7.5 feet. There have not been any prior variances for the subject property. I would like to add, if it wasn't clear in my staff report, that they're not encroaching any further than what they already are. They're just extending the boat slip because it's too shallow at that point, so they have to.
Moving it out some.
Right, but the current boat dock doesn't meet the setback requirement, so they have to apply for variance. So
Gotcha.
that concludes my presentation.
Any questions for staff?
Yes, a question for staff. If you could leave that photo on the screen. The application mentioned that there was an outfall structure from some sort of county stormwater system. Where is that in relation to the dock?
I wouldn't.
Maybe the property owner could.
No, I wouldn't.
Okay. All right, I'll save that for the applicant then.
Any other questions for staff?
Thank you.
Is the applicant present? Could you come on down, sir? I know we have at least one question. Please state your name and address.
Yeah, Peter Devoni, 114 Camphor Tree Lane, Altamont.
Okay. Is there anything you would like to tell us before we ask you questions?
No, I think she covered it well.
Okay. What is your question, sir?
Okay, I'll repeat the question. In your application, you mentioned that there's an outfall pipe from county stormwater. Where is that in relation to your dock? If you could point to the picture, please.
It comes out right here. You can't see it, but there's a storm drain that goes along this property line, and the head wall's right here.
Okay.
And it deposits debris right here at this location, and that's what's causing the boat dock to be unusable.
All right.
So it's silting up basically from the
Yes, sir.
storm drain?
Leaves and silt, et cetera, right?
Okay. Thank you.
Any other questions? Thank you. Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? Do we have a motion?
Move to approve.
Second.
Motion to approve. We have a second. Any discussion? All in favor of the motion, say aye. Aye. All opposed? Motion carries. Good luck. All right, next item.
Item number 6 is a request for a rear yard setback variance from 30 feet to 26 feet for a covered patio in the R1 Single Family Dwelling District in the Chula Woods subdivision located at 546 Chula Woods Court. The proposed covered patio will be 273 square feet and will encroach 4 feet into the required rear yard setback. There have not been any prior variances for the subject property, and this concludes my presentation.
Any questions for staff? Okay, is the applicant present? Sure. Good evening. Please state your name and address.
Gregory Raymond, 546 Chula Woods Court, Chuliota.
Okay.
So I'm just looking to build a patio extension. It'll just be a sloping out roof coming out 13 feet from my roof line. I have that existing patio there. So I guess I have a 30-foot setback requirement, and I'll be 4 feet crossing into that. I have 39 feet from my house to the fence currently.
Okay. Any questions for the applicant? All right, thank you.
Thank you.
Is there anyone else to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair, motion to approve.
Motion to approve. Do we have a
Second.
We have a second. Any discussion? All in favor of the motion, say aye. Aye. All opposed? Motion carries. It's approved. Good luck. All right, item 7.
Item number 7 is a request for a side street south setback variance from 25 feet to 13 and a half feet for a detached garage in the R1A Single Family Dwelling District in the Woodcrest Unit 1 subdivision located at 5001 Palmetto Avenue. The subject property is a corner lot considered to have 2 front yards for setback purposes. The front of the house faces Palmetto Avenue. The Citrus Avenue side is where the variance is being sought. The existing 1,280 square foot detached garage was issued a building permit, permit number 22-5727, that was approved to be constructed at 15 feet on the south side street setback and was built at 13 and a half feet. After inspection, traffic engineering has no objection to the placement of the attached garage as it relates to site visibility. 2 letters of objection were submitted and placed on the dais for your review. There have not been any prior variances for this subject property, and this concludes my presentation.
Any questions for staff?
Yes, I have a question for
Yes,
staff. Part of the application for this one included expanded narrative of the homeowner's experience with the county office, and my question for you is, now, I'm not trying to imply any misconduct on the part of staff. I'm a public servant myself, so. What do you think happened? Did the staff get carried away or give bad advice, or did the homeowner misinterpret something that he was correctly told?
Okay, so last June, our zoning technician passed away, you know, Ashley, and she was under the permit review process with this permit. After Ashley passed away, I then picked up her review until someone else was hired. I remember speaking to the applicant and telling him that I will seek, it has to be at 15 feet for traffic engineering to approve it. I'll send it to site plan review and we'll get through the process, and apologized about the delay. Traffic engineering can't approve anything below 15 feet, so it was never approved at 13 and a half feet by traffic engineering. They do not have the authority to do that. So it was approved at 15 feet. The site plan that was stamped and sent out on site with the building permit was stamped at 15 feet, not 13 and a half feet. It even said 15 feet with the applicant, what the applicant submitted. Upon inspections, it stopped at final inspection and was denied. And that's where we're at right now.
So they measured it and it was wrong, basically?
Yes. I mean, maybe they were using a fence.
Well,
Some people assume the fence is.
No, that's not what I would love to talk about.
Okay, yeah, sorry.
we'll give you a chance in a minute. All right.
So that, since I was the one that finished reviewing the building permit and approved the building permit, that was my experience.
Okay. Any other questions for staff? Applicant, sir?
Yes, sir.
Come on down. State your name and address, please.
Yeah, my name's Jacob Kuzman, 5001 Palmetto Avenue, Winter Park, Florida, 32792. Her story is mostly absolutely correct, except she forgot to mention that with that submission to her that day, or to them, because it was a gentleman also helping us, that there was also a variance application that I filled out fully for submission in case traffic and engineering couldn't get to that 13 and a half foot. And the only reason, even though they told me that traffic and engineering couldn't get to possibly 13 and a half feet, I said, I understand that in most situations. Oh, I didn't know there was a mic here. I was like, I understand that in most situations, but one thing you're failing to consider is that my house already is at 13 and a half feet. It's already there, right? So all I'm trying to do is line this thing up directly with my house so it looks perfect from the front. And we actually have a master plan for this house because my mother and father and sister and nephew and niece will be moving into this house by the end of the year. So we have about 150 grand slated for an entire renovation of the entire property. First part was just this garage project so we can get the RVs out of that backyard and into shelter. But the 13 and a half foot variance application, she didn't mention, that was also handed in with that large 3 foot by 4 foot survey to see what traffic and engineering would say. The reason why we also gave that $300 check and that additional application for variance at that time was because in case they couldn't get it to the 13 and a half feet, then we already had the variance stuff ready to go because we were behind schedule and we were trying to move this thing as fast as possible. So I got a call one day in around June or July, and it was from the planning office. A young lady reached out to me and said, hey, great news. Everything's good. You're good to go. I was like, good to go? And I'm like, that's awesome. That's great news. And I did not ask very specific questions, but the one question I did answer, she asked me, what do you want me to do with your variance application and your personal check? I said, well, if I don't need it and I don't got to go to variance, then destroy it. I don't need it. I wish I would have asked now for a copy of that back so I had proof of that. But what they failed to maybe note or didn't think of when traffic and engineering came back at 15 feet was that there's a variance application there in their hands for a 13 and a half foot variance. So if I didn't get the 13 and a half foot through traffic and engineering, like I was told most likely can't happen, then the next step was to submit for the variance right away. The reason why I thought possibly there was a chance in heck that traffic and engineering would make that exception regardless of what they were telling me was only because my house is already at 13 and a half feet. And this is a very unique property. And many, many years ago, when the prior owners built the fences and the city came back and rebuilt the sidewalks going around the property, they literally expanded this property out. So my building, even as it were to sit at 13 and a half feet, is 42 feet away from the street. And 30-some feet away from the sidewalk alone. Not to mention, it's completely hidden behind all the trees, bamboo, and brush that the property has had since before I bought it. So anyways, it was only at final inspection upon completing the building that then we had a building inspector come out. And in fact, it wasn't a building inspector. This is actually how this came about. The gentleman next to me who owns the engineering company, Henry, he decided to illegally dump stuff on my property. He cut all my trees off his property line, dumped it then all onto my property. So I went over to the gentleman to introduce myself, have a talk with him, see why he dumped all this stuff, because we had cameras showing him dumping all this stuff on my property. And he admitted to it all, and he said, well, he had called the county, and they said because it was my trees, he was allowed to have done that. So for me then asking him first off, will you pay me a few $100 so I can remove it? Because I have demo people coming, I can grade and remove this stuff anyways, but I don't want to pay for your trees that you put on my property. And not to mention, killed a ton of new landscaping we had just put in. Huge, very expensive plants he just completely trampled with all these oak tree branches. Well, that Henry guy, probably one of the objection letters, my next door neighbor, he said, no, screw yourself, I'm a lawyer, take me to court, do whatever. I said, okay, so I filed a police report on him. That went to the state attorney, and now I filed a civil lawsuit against him just because, like, he's bullying me and he's just trying to take advantage because he's been there forever, right?
Okay,
But so then what happened was he decided to call in to say that fences were out of place, that they weren't within my property line. I'm like, what are you talking about? They've been there for 30 years, it's not my problem. And county did tell me, yes, your property line's back here, those fences are out. So I had to go and remove all those fences you see there. Those are all gone now. I have no fencing around my property now. Probably can never put fencing back because of how the property lines are structured. So it is what it is. But this is how all of this started coming about. And as soon as that came about, that's when an inspector came out to my property, did some measuring with the property lines from the fence issue. And we're already built basically, or the foundation's already poured. And they're like, hey, why are we at 13 and a half feet? And I'm like, what do you mean? I'm like, I got a call from your planning office last year saying we're good to move forward. And it's more of just, it's a miscommunication by far between myself personally and whatever lady I was speaking to on the phone that day in not pushing forward my original variance application. And this is why we're back here just a second time. I think that can probably conclude most of my statements for this right now.
Didn't they give you a copy of the approved site plan?
No, because I'm not building. I hired a general contractor to build this building.
But he would have got a copy of it.
They would have gotten the copies and done all that. So
he should have saw the 15 feet and questioned it.
Possibly. Well, we already knew the 15 feet was in place for a while because we were actually holding up for the 13 and a half feet. We didn't want to build anything. We actually already had forms built at 15 feet from the concrete guy. We had the forms up and everything. As soon as I got the call from planning offices, that's when we called the contractor. I paid an additional $1,500 to the TNT concrete. They moved all my forms to 13 and a half feet. We started pouring. I mean, that's how fast we got this thing moving as soon as we heard that news. So I'm going to say it's probably my fault more than anything by instructing these based on that conversation I had that day and not, I was very excited to get this thing going, that's all.
All right.
It is what it is.
Any questions for the applicant? Okay. Thank you.
You're welcome.
Is there anyone else to speak in support of the request? Okay. Carol Swanson.
Yes.
Good evening. Please state your name and address.
What?
Your address?
Oh, yes. I live in the Woodcrest subdivision at 7445 Houston Court East. I'm a retired attorney, and this is in my front yard, basically. I'm very opposed to this. Mr. Kuzman doesn't live in Seminole County. He lives in Orange County. This is a rental property at this particular point in time. He's taken a small house, cute little house, and he's put a 2-story metal garage in back of it. So I'm living in Woodcrest. To my knowledge, not a single house in Woodcrest is 2 stories. They're all single-story houses. So my friend walks into the house and says, "Did you know they're putting, a mechanic's got a garage going in at the front of your subdivision?" I said, "What?" So I go down there and look. This is 2 stories. It's got 4 bays. It looks like an 18-foot door, but I'm a woman, who knows? It might be bigger or smaller. So I thought, well, what are they doing that? They're ruining our property values. So I thought, well, I've heard about this thing called Neighborhood Northeast. So I post up something on Northeast. To my shock, I got 4,500 views. I got all kinds of conversation, not 4,000, but I got all kinds of conversation. The people were all over the map, back and forth. But one theme ran through it all with people who don't understand zoning. They were saying it's commercial. Well, I think they might have a commercial. They can put commercial. No, they can't put commercial. It looks commercial. It doesn't matter what his use is. As you know, as an attorney, it's not just impropriety, it's the appearance of impropriety. It's not just his use, it's the appearance that it's commercial. So I called code enforcement. They were shocked. They couldn't believe zoning gave him a permit to put that eyesore at the front of our residential subdivision. You ought to go look at it. I can't imagine any one of you wanting that sitting at the front of your subdivision. I don't. I mean, it's R1A. That's meant, the overall philosophy of that is to improve where we live, not make our property values go down. And one thing I'd like to leave you with is 50 years from now, when Mr. Kuzman is gone, who's going to want to buy a cute little house with no backyard? It's got this huge fence right behind the back door, not far from the back door. And then the rest of the yard is consumed by this behemoth. So I want to present to you my notice that I had 4,500 views. I can assure you I had a lot of conversation on the whole thing. This is a picture of the house. When you look at the front of it, it's a cute little house. It's yours.
The house will look exactly like my building by the end of this year. Just FYI,
I'm speaking.
And it's a one-story building.
I'm speaking.
Okay.
Who's gonna, one lady said, I practically had a heart attack when I saw it. Who's gonna wanna buy that cute little house with no backyard and that great big garage in the back? I vehemently do not want you to put this nonsense in my front yard. Additionally,
your new zoning code's coming out, and I was told by, let's see, Mary is it, I believe? She said this building would absolutely not be approved under the new code. So you're going to have, you may have people coming in, well, they put that great big behemoth at the front of the subdivision, why can't I do it in the back of my house? You know, it may be an ongoing problem for all of you. But anyhow, a lot of my neighbors and I do not want this mess in our yard. Let him put it in his backyard in Orange County, not in my front yard.
Okay.
I'm 2 blocks. Do you have any questions?
Yes.
Go ahead, sir.
All right. Us being a quasi-judicial body, are we allowed to consider hearsay in our consideration for our decision?
We should be looking for facts.
The statement of what the employee at the planning office said the new code is going to be, and that this building
Well, what the new code is going to be doesn't affect us at the time the current code is in.
I can't hear
Exactly.
you. I'm sorry. What did you say?
He was asking about changing the code. The code is the code until it changes.
Right.
And then it becomes an issue for
So it's a moot point to begin with.
the moment, yes.
He's probably vested with the old code anyway.
Right. And furthermore, Ms. Swanson, you said yourself that you are vehemently against the presence of the building in the backyard of this property. However, it seems that the building has otherwise met all its other requirements. The only thing that's under consideration for us here today is the setback, where on the property this building can be. So I understand your opposition to the building itself, but that's not exactly what we're considering.
You're looking at the trees. You're not looking at the forest. The overall concept of your code is to make it better for us, better for the residents, not worse.
Well, let me restructure my question in a different way. If this building was located 1.5 feet further back from the property line, you would still not be happy with the presence of the building, correct?
That's correct.
All right.
Okay.
That answers my question. Thank you.
So the point he's making is, if he decides to either move it 1.5 feet back or shorten it 1.5 feet to make it 15 feet, there's nothing we can do about it. He can build the building.
Unless the code changes.
Unless the code changes. But at the moment, he has the right to build under the current code.
It's not going to happen? Is that what you're saying, Mr.
No.
Hadaway?
I'm saying what you said about the new code is not entirely correct. So
What? I'm sorry,
Go
I
ahead,
can't, I have trouble hearing.
What you're saying about the new code is not entirely correct, so you might not want to rely on that, but I'm not
Okay.
going to give legal advice up here on this
Right,
dais,
I
though.
understand.
I do have a question, and if it's...
Yes, go ahead.
You mentioned your property rights would be damaged, and I worship at the Church of Property Rights, so I need to ask, which property right is damaged?
The value of my property.
Have you had it appraised?
I'm getting it appraised right now. And currently, the house, my particular house, is around $350,000. And this is not going to help appraisals.
So it's not that your property rights are damaged, you're just concerned about property value?
Absolutely.
Gotcha. Thank you, ma'am.
Any other questions? All right, thank you, ma'am.
Well, a lot of upset neighbors.
All right.
Thank you.
Is there anyone else to speak in opposition to the request? Okay, do we have a motion?
Mr. Chair,
Yes, sir.
motion to approve.
You have a motion to approve. Do we have a second?
Second.
We have a second. Any discussion? Okay. All in favor of the motion, say aye.
Aye.
All opposed? Aye. The motion carries 3-1. It's approved. Ma'am, you have 15 days to appeal it to the Board of County Commissioners.
I will.
Okay?
Thank you. I don't know what's allowed. Can I just make a statement or no?
Well, your variance was approved, sir, so I would run with
I
it.
wanted to, I'm a property right line guy.
We're-
Take care of our
It's okay,
properties.
we're done. All right, next item,
Thank you
please.
very much.
Are we ready for the next item? Item number 8 is a request for a rear yard setback variance from 30 feet to 6 inches for a guest house in the R1A Single Family Dwelling District in the Sunland Estates subdivision located at 209 Collins Drive. The detached guest house is approximately 392 square feet. The variance granted applies only to the size and setbacks as depicted on the site plan. A building code violation was issued for unpermitted construction, code violation 19-254. The applicant applied for a building permit in 2020, permit number 20-10445. However, it was denied because the special exception and rear yard setback variance was needed. The use of the guest house is contingent on the approval of a special exception by the Board of County Commissioners, goes before the Planning and Zoning Board on August 2nd of this year and BCC September 12th of this year. And this concludes my presentation. Should you have any questions for staff, I'd be happy.
Questions for staff? Okay, is the applicant present? Okay, come on down. Please state your name and address.
Okay, my name is Nini Vega Castillo. My address is 209 Collins Drive, Sanford, Florida, 32773. He's my husband.
And what's your name, sir?
Victor Garcia.
Okay. And what would you like to tell us?
Well, to be honest, can I speak first?
Okay, go
Okay. We have this issue, we don't know when she bought the house. We don't know whoever sold to her, he doesn't put the permit to build it, the little house in the back. So when we make we put a permit to put a fence on the sides, so the inspector go there and he's seen at the house. So that's when we start, we're gonna have to put the permit and we need a setback for the little house. The only thing is when the previous owner, he built the house, he built right there where the edging of the property is. So in between our house, the main house, and that little house, it's not even 20, probably not even 25 feet anymore from in between both houses. So when we start doing this, we're coming to over here. So we have a little shed in the back. So they told us to take it down, so we take that one down. Also, inside the little house, we take some of the stuff out too. So we've been doing everything what the county say to fix this thing right, to be honest.
I stayed for 3 years almost.
Okay,
The
so
same
you,
process.
Yeah, everything what they say, we've been doing all the time.
so you bought the house and the building was already there?
Yes.
And then when you tried to replace your fence, you found out it shouldn't be there?
Yes. That's when, because she put the permit to build the fence, that's when the inspector, he said.
For the dogs.
Yeah, because we had 2 dogs.
Okay, refresh my memory, I'm familiar with the neighborhood. What's behind your house? Is that just woods?
It's all woods. It's basically is where the flea market used to be, all that property
Right,
is right
that's
there.
what I thought.
And I guess a little river in the
We
back.
incorporate this size and incorporate.
Any questions for the applicants? Okay, thank you.
Thank you.
Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair, motion to approve.
Motion approved. We have a second.
Second.
We have a second. Any discussion? All in favor of the motion, say aye. Aye. All opposed? Motion carries. It's approved. Good luck to you. All right, next item.
Good evening. For the record, Hillary Payton, Planning and Development. Item number 9 is 2 variance requests for 9709 Bear Lake Road, located in the McNeil's Orange Villa subdivision. The requests are for a rear yard setback reduction from 30 feet to 6.8 feet and a south side yard setback reduction from 10 feet to 2.19 feet for an accessory structure in the R1AA zoning district. The request is to bring into compliance the construction of a 338 square foot shed that encroaches 7.81 feet into the south side yard setback and 23.2 feet into the rear yard setback. On May 19th, 2003, the Board of Adjustment granted 9 variances for the property relating to various structures on it, but 2 of them were for this structure. The south side yard was granted a variance to 2.66 feet and the rear yard to 8.7 feet, but the existing structure exceeded the prior approved variances. And a code enforcement violation number 22-87 was issued for this structure, resulting in the necessity of this variance. This concludes my presentation. I'm available for any questions.
Okay, so we approved 9 variances, including some for the structure, and they got put up in the wrong place anyway.
That's what it appears to
Basically.
have happened.
Okay. Was it this owner that received the variances?
I don't believe so.
It was
I'm
a
not
previous
sure.
owner? Okay, I'll ask.
I don't recall.
Okay. Any questions for staff?
Yes, question. So the structure in question that was covered by 2 of the 9 variances that were originally issued in 2003, was it already existing at the time that the variances were issued, or was it still conceptual?
I don't recall.
All right, because that would make a difference to me whether that structure was already there, the variances were issued to bring the structure is on the property in compliance with code, and the wrong setbacks were given or communicated to the homeowner, as opposed to variance was applied for, was given, but was then constructed in the wrong spot. Those are 2 different things, and I would like some clarification on that. If not from you, then from the homeowner, if possible.
Yeah, I don't have that information.
Okay.
Any other questions for staff?
Kathy Hamill, Principal Planner. The site plan that they provide to us as part of the variance process, they are the ones that are providing us information. So if they provided incorrect information about the setback, that burden, if the inspector went out and it was incorrect, that burden would be back on the applicant. So for me, even if it was something that was constructed afterwards, or they were given the wrong, they gave us the wrong setback when the
Okay.
variance was granted.
Okay, so that said, was the structure already there at the time the variances were granted in 2003 or not?
My assumption would be that it was, considering the precise numbers that were given even in the 2003 variance.
Okay.
I assume that the structure was already constructed at that point, but I don't have that information.
Those are the most precise variance figures I have ever seen. Mike Hadaway was in rare form back then. Anyway. Okay, is the applicant present? Is there anything you would like to add? Come on, Ed. He has a question for you for sure, so. Please state your name and address.
Okay, mi nombre es María E. Bonilla. I live in 9709 Bear Lake Road.
Okay. Is there anything you would like to tell us before we have questions?
Okay. Compré la casa hace 2 años, 2 añitos en... My son?
Oh, is it easier if I just translate what she wants to say like right away, or just go one and one?
What works for you? We just need to understand what she wants to tell us.
Well, my name is Bill Martinez. I'm her son.
And what's your address, sir?
9709 Bear Lake Road, Apopka, Florida, 32703, if I'm not wrong. So she purchased the property as is maybe like 2-3 years ago, and she didn't know or didn't receive any paper of any code violations. So when she put it back on the market for sale, that's when she noticed about code violations she received. So at first, she hired an architect to bring it to permit to leave it as is. And then we came here again, I guess, November, October. And then it was easier to convert it back to a shed. And that's when we started. She started doing it like owner parent because her architect wasn't not working at all. And since she's just following the steps, basically, what they're telling her what to do here.
Okay. What are you want to ask her your question?
No, I don't anymore. After looking through the application, looking through the property appraiser's records, it's obvious that since the original house was first constructed in 1977, this property has changed hands so many times over the years that the property owner at the time that this was constructed is so far in the past.
Okay.
Yeah.
Any questions for the applicant? Okay, thank you.
You're welcome.
Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair,
Yes, sir.
motion to approve.
We have a motion approved. We have a second.
Second.
Second, any discussion? All in favor of the motion, say aye.
Aye.
All opposed? Motion carries. It's approved. Thank you. Good luck to you. It's hard to clean up somebody else's mess, I know. So good luck.
Thank you.
All right, next item.
Item number 10 is a variance request for 4572 Old Carriage Trail located in the Stonehurst subdivision. The request is for a rear yard setback reduction from 30 feet to 7 feet for an accessory structure in the R1AA zoning district. The request is to cover an existing 743 square foot concrete slab with sunshade sails 23 feet into the rear yard setback. The applicant provided an email from the Stonehurst HOA stating that since the structure is not permanent, their approval is not necessary. However, I later received correspondence from the HOA in opposition of the structure as it is not temporary. This concludes my presentation. I'm available for any questions.
Any questions for staff? Yes, sir, Mr. Atway.
When you had mentioned that letter, I read that. Do we know for sure whether that letter is from the association or from a member? Because when he writes it, he just says, "I'm a member of," and he uses, personal pronouns when he's writing it. And I don't know whether that actually is from the homeowners association. Do we know for sure?
I can only go based on what he says in his letter. He stated that he was
Just a member, but not speaking on behalf of. Am I wrong in that?
Let me pull it back up.
I'm sorry, I left my iPad at home.
I've
I don't have
received
my
so
packet.
many letters.
Yeah,
this
I know
variance
you do.
cycle.
Yeah.
I don't have it.
And then which one are you
This
guys?
is it right here, signed as the president of the HOA.
Yeah. I am the current president. I write this letter with reference.
And it was written in his capacity as
Is
the
to
president of the
document
HOA.
my opposition. Not that the board, it doesn't reflect any
Yeah.
official action. Oh, we'll ask people. Yeah. We'll get that answer.
He also addresses this having been raised in the past and reviewed by their legal counsel.
Oh, yeah. Take it.
Great, thanks.
Do we have any other questions for staff? Okay, is the applicant present?
Yes.
Come on down. State your name and address, please.
Yes, Mike Stapp, 4572 Old Carriage Trail. First of all, I was a member of the board, and I actually have an email from the board when I applied that approved, that stated it was not needed because it was going to be a temporary sale. The intent is, originally when this was built, I had a roof on it, found out it was not compliant, so we took the entire roof off of it. So then I went to the board and said, okay, what are my options as to what we can do? So the plan is to put a post in the middle. I've got right now 8 posts, and my intent is, and they're all 3 feet sunk and concrete in the ground, and my intent is, well, I've already thrown away $20,000 taking the roof off, so how can I utilize what's left to be able to eliminate additional expense? So we've designed to where it'll be basically in quarters. There'll be 4 sails They will be temporary because they're going to be attached by hooks, so they'll have the ability during a hurricane to come down to be able to do that. In addition to that, and I can, you can let me know who the individuals were, and I can tell you if they're on the board or from the HOA.
I'm not going to try to pronounce his last name, but you're more than welcome to look.
Well, that gentleman,
He says he's the president.
he's the new president that just took over effective January 1st. The HOA, Nick Sabilo, is the director of it, has approved. I have an email that stated it does not need HOA approval because in their opinion, it's a temporary structure and has the ability to come down. So he might not, that might be the new president, but this was all applied for before and it's been handled since. So, like I said, the intent is to just have temporary for sales and have an area outside. That's an old basketball court that's been there 20 years. And I'm just trying to utilize, since my 3 boys are grown and gone, how can I utilize the space? And that's my intent.
Okay. Any questions for the applicant?
Yes, question for the applicant, right here. You said that the new president, Mr. Umlauf, came into office in January of this year.
Right. But the HOA members have not changed, and the director of the HOA is the one who approved the ability to put the sun sails up. So just because he's the president doesn't give him the ability to deny. But the HOA is
Not
approved.
necessarily. That would depend on the covenants of your HOA, would it not?
Well, the
This
HOA's
person who,
approved it.
Well, the person who approved it was Nicholas Sabilo, who was head of the ARB.
And he still
is. Again, this would depend on how your HOA is structured, but the ARB answers to the association. Do they
It
not?
does not. It does not. Stonehurst, it does not. They are 2 separate areas. Because we've had situations in the past, I was a vice president of the board last year, when the situation was the ARB operates completely separate from the HOA, from the board, because we've had situations and the decisions, we've had discussions in the meetings that is an ARB, it is not a board decision.
All right.
Yes.
I'm not saying that isn't possible for an HOA to be structured that way. That's just not my experience with the developments.
We
in which
specifically had situations last year because the president of the board, a gentleman by the name of Bob Jordan, I was the vice president, and we specifically, when this item was brought up, the ARB and Bob and myself said, we're off to the side. This is not a board decision, the ARB, and I can get documentation for that.
All right. So
again, the intent's just to use the existing structure that's there.
The ARB approval I saw in your application was given in an email Monday, February 20th of 2023, which was after Mr. Umlauf was already
Right, but the
sworn as the
ARB
president.
approved it.
Okay.
Yeah.
So you're saying that the ARB approved it, you should be good to go. The fact that the president of the homeowners association does not approve it, you're saying he does not have the power
That's
to disapprove that?
That's correct.
All right.
And as a technical issue, we are not allowed to base our decision upon the approval or disapproval of an HOA. We can take it as input as property owners, but we're not bound by their decisions.
You are
To approve or
correct.
disapprove.
However, this is the first time in my admittedly short, well, I don't know, year, 2 years, tenure on this board that we've had an application come before us where the property in question is located in an HOA, and it has in the application, the HOA does, the board, whatever, you're saying the ARB has it. This is the first instance where some element of the HOA has rejected or disapproved of the change in question. Now, I agree with you, we're allowed to make our own judgment. The judgment of the HOA is not dispositive on us. But I do want to ask you, however, knowing that this is, as much as you might not want to admit it, this is under dispute as far as whose say on the HOA is going to carry the final word. Do you still want to go forward with this, with your proposal, knowing that your HOA might come down on you.
Yeah, I feel very confident, because option one is to use the existing structure as is, put the 4 sun sails and be done. Option two is to take everything out, which means I've got 8 posts, 36 inches down, I've got to cut everything down. Then I will then go and file a permit to be able to put up a structure that's going to have posts, that's going to have the sun sails, okay? And feel very confident with that. So all I'm trying to do is limit the financial exposure as to what we're going to do, because from a design standpoint, with the architect who's done the sun sails, with the posts 36 inches down, they feel pretty comfortable from a weight-bearing standpoint. I'm going to be in pretty good shape. And that way, the other option is to take down the wood and to put in metal corners all the way around and put in 4 sun sails, which still is going to be not be more higher than 12 feet high. That's still going to be compliant because it's going to be a temporary structure. So the whole intent, when you look at the variance, it says from 30 feet back, is because the posts are considered permanent. That requires 30 feet. The post in the back is 9 feet 6 inches from the property line. So that's the reason for the 30-foot setback, is because they're deeming this because it's already there as a permanent structure. Is what I was told from the county when we made the application.
Is that all your questions, sir? Any other questions for the applicant?
Mr. Chair.
Yes, sir.
You said a center post. What the height is on that one?
It will not exceed 12 feet, which is the requirements of the HOA. Yeah.
And I mean, I'll ask you the question, but it may go back to staff. I know you refer to the structure that you have in place, that pad, the 743 square foot pad, and the post. You were denied at that point, and you had to take the roof down on that?
No, when it happened, I hired the GC who built it for me and found out he'd never pulled a permit. So then one of my neighbors who's here notified y'all, and then they came out, basically said you're in violation. So I said, okay. So I took the whole roof off, tongue and groove, everything right down. And that's when we made the decision to say, hey, we're going to, because the other issue is you can't have a permanent structure more than 240 square foot. So the sun sails gave me the ability to avoid that because they're not permanent. So that's the workaround.
Thank you.
Okay.
I guess follow-up question to that is, prior to, I think I'm just asking this for my opinion, but prior to pulling the roof down, did you talk to the county about applying for a variance at that point for the structure that you had in place?
No, I didn't, no. Because I didn't think going from 780 feet to 240 was an option. Yeah, and it was also a violation of the HOA, because the HOA had guidelines at 280 feet. So, yeah.
Thank you.
Okay, any other questions? And I think you'll find 12 feet is the limit for a shed too.
Yeah.
In height.
Yeah, so.
All right. All right, thank you, sir.
Thank you.
Is there anyone to speak in support of the request? Okay. Steve Olson. Good evening.
Hi, Steve Olson, 4532 Old Carriage Drive, or Old Carriage Trail, Oviedo, Florida, 32765. I'm in education, and I'm a visual learner, so please bear with us, but this is the variance he's asking for. The red is the variance, and the green, or excuse me, the yellow is how close it will be to our property line. So it's about 7 feet away, and ironically, I came in here when a meeting wasn't done, and from those first couple rows up, it would be like moving those seats right up to the front where you are. Our backyard, thank you. Our backyard faces behind him directly. This is seen from our kitchen, our living room, our family room, our bedroom, and a bathroom. So every window out of the back of the house sees this. So he is absolutely correct that when they put up this outbuilding here, this was the outbuilding as it was with the roof. Those are 2 shots of it. And here's some shots taken directly from our property line that shows you how close it is to our property line. He says it's not a permanent structure, but it's tied into a permanent structure that was not approved and is not approved. The president who wrote the letter cites section 8.8.1, which among other things requires a 30-foot setback. We would ask that you do that. Also, this isn't approved and it's part of the old building, so we would ask that that be in compliance and adhere to those setbacks. Secondly, our documents, section 8.9.3, stipulate that no outbuilding or accessory structure should exceed 12 feet height measured to the ground, which this doesn't, or have 240 feet around, which this does. In addition, buildings, one thing the president doesn't say in his information is non-permanent buildings such as tents are not allowed. So that is in our documents as well. And what we're asking for is the fact that we don't see this every day, because as he said, it could come down during hurricanes, but otherwise it's there. So we ask you not reward him for any thing that happened using the structure. If he wants to apply, if he wants to get board approval, the other letter you have there from Nick Silvio, who's the head of the Architecture Review Board, when we talked to him, he didn't realize he was using the permanent structure, and he doesn't have approval for a permanent structure. So what in the email that was sent, I believe they say it's a non-permanent, but those would be permanent. So for all those reasons, we would ask you to please vote no. Thank you.
Any questions? Yes, sir.
Mr. Olson, is there any way that your neighbor could modify the way he's doing that would be acceptable to you?
Interesting you should ask that. When he initially was doing the work, and Mike, nice guy. We've lived behind each other for what, over 15 years, and never had an issue. When this came up, he asked me that exact question, and I just said, well, I'm going out of town. Let me think about it. Let's, don't do anything. Just don't do anything till I get back. Let me think about it. And the construction continued when I was out of town. So at this point, I have to adhere to what the HOA says, because he's absolutely correct that Bob Jordan approved that, and we got a letter from our attorney that I hadn't seen last year that the president and vice president last year, in my opinion, worked in their own self-interest to get this pushed through, and the new board saw that it affected the HOA documents, and it's not allowed, so I would say no.
Gotcha. Thank you, sir.
Yeah.
All right, thank you. Is there anyone else to speak in opposition to the request? Okay, do we have a motion?
Mr. Chair?
Yes, sir.
I move to deny.
We have a motion to deny. Do we have a second?
Second.
We have a second. Any discussion?
I would just say, everybody has a right to go tilt at windmills if they want to and go fight their homeowners association. You're right, it's not dispositive on us, but, it's when people have a right to stand on their rights, and if a neighbor wants the rules to be followed, the neighbor has, at least as far as the county is concerned, I have a great deal of respect for that.
Yeah, it's an intrusive structure with the pictures with the roof as far as visually. You definitely can see it. I mean, it's right there. If it was completely within the setback, it wouldn't be in front of us then, but if it was within the setback, I would be like, if it was legally up, it's legally up. But I agree. Okay. Any other discussion?
Yes. Furthermore, I put the letter in front of you, Jim. That letter there is from the same person who gave, it's the chair of the Homeowners Association, ARB. That appears to be a clarification or expansion upon the original approval that was given. That appears to be revoking or taking that back under the pretense that this person was not aware that the structure in question actually is permanent and not temporary, as he was led to believe when he issued the approval in the first place. Given that the structure, the framework of the structure was already there, I don't think it's like the property owner relied upon the initial approval of the HOA to go ahead and build anything or to go ahead and do anything, minus whatever was spent on the architect. For that reason, well, among many, for that reason, I agree with Jim.
Okay. All in favor of the motion to deny, say aye.
Aye.
All opposed? Okay, motion carries. It is denied. You have 15 days to appeal to the Board of County Commissioners. Staff can help you do that, sir. Okay, good luck to you. All right. All right, next item.
Item number 11 is a variance request for 127 Varsity Circle located in the Academy Cove subdivision. The request is for a rear yard setback reduction from 30 feet to 23.5 feet for an addition in the R1A zoning district. The request is to construct an 18-foot by 18-foot single-story office/bedroom addition to the rear of the existing single-family home, encroaching 6.5 feet into the rear yard setback. The Academy Cove Homeowners Association has approved the request. 2 letters of support have been received from the rear neighbors. This concludes my presentation. I'm available for any questions.
Any questions for staff? All right, is the applicant present? Is there anything you would like to add? If so, come on down. We saved the best for last tonight.
Thank you. Name is Joseph Harmon. I live at 127 Varsity Circle. Yeah, just wanted to point out that the area we're looking to build into is abutted by our pool enclosure and the shed, which has existed, I think, since the late 90s. One of their previous homeowners erected that. And I had a question for the board. Our HOA actually has a 25-foot setback requirement, and the board was actually curious if anybody knew why they might have had a different setback requirement than the county.
That was something the board chose to approve. So the HOAs can be more restrictive, but they have no authority to waive the county requirements.
Right.
So if the county has a 15 and they want to say 25, they can do that.
Sure.
But if the county says 25, they can't say 15 is okay.
Right, and that's what we just thought was odd, in that the county was more restrictive than the HOA, and we were just curious if in the past there was a different requirement.
It's hard to say. No telling how that came about. The county could have changed it at some point, or the homeowners association wasn't aware of the county, or it's hard to say.
Yeah, okay. That's all I had.
Okay, any questions for the applicant? All right, thank you. Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair, motion to approve.
Motion to approve. Do we have a second?
Second.
Second. Any discussion? All in favor of the motion say aye.
Aye.
All opposed? It carries. It's approved. Good luck to you. All right, item 12.
Item number 12 is a variance request for 2205 Winnebago Trail located in the Indian Hills subdivision. The request is for a south side street setback reduction from 25 feet to 7 feet for a privacy fence in the R1A zoning district. The subject property is a corner lot and has 2 front yards for setback purposes. The front of the house faces Winnebago Trail. The Osage Trail side is where the variance is being sought. The request is to bring into compliance the construction of a privacy fence encroaching 18 feet into the side street setback. Traffic engineering has no objection to the placement of the fence as it relates to site visibility. The proposed privacy fence encroaches into a utility easement, and that building permitting will be required to meet the criteria for placement with an estoppel letter. The privacy fence is 7 feet from the sidewalk and 18 feet from the edge of pavement. A code enforcement violation, number 23-58, was issued for this fence, resulting in the necessity of this variance. 7 letters of support were received from adjacent neighbors, and a letter of opposition has been received from the directly affected neighbor and provided to you for your consideration. This concludes my presentation. I'll be available for any questions.
Any questions for staff? Okay, is the applicant present? Come on down. You're ready, you're rolling.
It's been a long night, right, guys?
Amen.
My name is Bruce Smith. I am the new resident and owner of 2205 Winnebago Trail.
I think he's got it over there.
I'm sorry.
May I have this, please? Sorry, please continue.
Oh, no.
Go ahead, sir.
All right. Yeah, so basically, I closed on this property on April the 20th. As you guys saw, there's a permit issue that was issued. The previous owner did not take care of that issue. Basically, the variance is just approved for the fence where it's currently standing. Along Osage, that fence has been there since about 2004. And so basically, I'm just asking for a variance to keep the fence where it's at. Don't know really how much we can go into that, but that's pretty much it.
All right, so this old fence was in the same place, you're trying to replace it in the same place with a better fence?
It has been in place since I purchased it. There was an issue, I'm assuming based on what my research has shown, the back fence has been moved at some point in the last however many months to a year. Since I moved in, there was an issue. From the previous owner, there was an issue showing on the survey that the fence for about 8 foot was over the property line on the back end. That was moved whenever I took possession. The previous owner actually paid for that. That's in the letter and all that good stuff. And as far as I know, everything was pulled back into compliance on that. Of course, knowing with the permit, I've already talked to the permit office. They're aware that I'm going through the variance, and of course, don't want to open up the permit until after the variance has already been completed. That's my understanding. I'm getting a crash course in, I guess, code enforcement and all that good stuff.
They say if you don't know it beforehand, you will by the time it's done.
I'm ready to serve on the board. We probably have a couple of positions for people to actually show up. So based on I've watched a lot of videos to understand what's going on. So, but yeah, I'm learning. So thank you for that.
Any questions for the applicant? All right, thank you.
Yep.
Is there anyone to speak in support of the request? Come on down. Please state your name and address.
Michael Hare, 2511 Osage Trail, Fern Park, Florida, 32730. I live on the affected, the back street, just 2 houses down from the subject property. My wife, my lovely, intelligent wife, saw the placard and panicked because she was sure that something horrible was going to happen to our beautiful, quiet, congenial neighborhood. And since I'm an attorney, she had me run headlong into this to right all wrongs and make sure everything's fine. I had the privilege of meeting Mr. Smith this evening, and I asked him, what you want is to keep the fence in place where it is, right? And he said, yes, right. That's perfectly fine with me. None of the other homeowners, every home on our street is owner occupied. It's a very beautiful area to live in, street to live on. We're very pleased that this home has been occupied, it has been purchased by Mr. Smith. We welcome him to our really, really nice little community. And I have no objection to the fence. It's a very nice fence, very new and clean and well kept. They decorated for the holidays, which is very, very nice. We hope he'll continue to do that. I have no objection to the variance for the fence to stay exactly where it is. I can't speak for anyone else, but all of the people on our street that I've spoken to have no objection. Everyone was kind of confused about what it was he was asking for, but I'm clear on what he's asking for, and I not only have no objection, I welcome him to our community.
All right. Thank you.
Thank you.
You have a question, sir?
Yes. So I did a double take when I saw this come across because it said you were speaking in favor, and I already saw your name on an email that says you were opposed, but it's obvious now you're retracting your opposition and you're fine with it.
A wise man changed his mind, a fool never.
All right, thank you.
I need that one form too. I have to turn it in.
That's what I was asking for.
I saw it far over there.
All right, is there anyone else to speak in support of the request? Is there anyone to speak in opposition to the request? We have a motion.
Mr. Chair, motion to approve.
Looking to approve, we have a second?
Second.
What?
We have a second?
Did you make staff
Any
gasp?
discussion?
Did you make staff gasp? One of those nights.
All in favor of the motion, say aye. Aye. All
I'm swayed by
opposed?
eloquence. What did I
Motion
say? I'm
carried.
sorry. Yeah.
Oh, it's only because there's an attorney.
Professional courtesy, come on. Gee.
By the way,
May I say I applaud your endurance?
thank you. And by the way, why are you putting a fence thing at the end of a long night with Hathaway present? Anyway, go
I
ahead.
thought I'd go home early or something.
All the videos that I watched, I'm surprised that you second, right? My heart goes out to you, so thank you.
Wow. Video, and that's a lie.
As a wise man once said,
You're a celebrity.
It's late. All right.
yes, I am.
Thank you.
At least we haven't had a meeting till 11 at night in a while.
Don't jinx us.
The last one I had was caused by a cell phone tower.
We're not out yet.
All right, next item.
Last item is what you mean to say, is a variance request for 5648 Autumn Chase Circle, located in the Autumn Chase subdivision. The request is for a south side street setback reduction from 25 feet to 10 feet for a privacy fence in the R1A zoning district. The subject property is a corner lot, has 2 front yards for setback purposes. Front of the house faces Autumn Chase Circle. The south Autumn Chase Circle side is where the variance is being sought. The request is to construct a 6-foot vinyl privacy fence 15 feet into the side street setback. The proposed privacy fence is 10 feet from the sidewalk and 23 feet from the edge of pavement. Traffic engineering has no objection to the placement of the fence as it relates to site visibility. A letter of support was received from the rear neighbor. The Autumn Chase Homeowners Association, ARB, submitted a letter in opposition to the request today and has been provided to you on the dais for your consideration. This concludes my presentation. I will for any questions.
Questions for staff? Okay, is the applicant present? Is there anything you would like to add? Come on down. Okay, state your name and address, please.
Alyssa McComb, 5648 Autumn Chase Circle, Sanford, Florida.
Okay, what would you like to tell us?
Just my partner and I purchased this home last year. We love the mature vegetation that it came with, obviously a big oak tree, and it's kind of difficult to see on that side of the house, but there are large flowering trees as well. We're trying to just fence it in for privacy purposes, but the oak tree makes it a little difficult to work around, as well as the mature flowering trees along the side. So we have to get creative with the fence placement. We'd like to keep the plants as they are because they're really nice. There's also a garden hose there as well, so just trying to make that area a little more accessible to maintain what's currently there, as well as accessing the garden hose. As much as we'd like to allow the fence to go with our rear neighbors, we have an open patio there and it doesn't line up exactly, so we have to work around that as well. I didn't know that the HOA submitted a letter. I know that there's been some back and forth between us on approval. The last thing that we were told was about setback, so that's why I'm here, to get the setback changed.
Questions for the applicant?
Yes, I have a question for the applicant. I brought this up earlier tonight on another applicant. I'm going to ask you the same question.
Sure.
Most of the time, when we have these applications come across for our approval, and the property in question is located in an HOA neighborhood, HOA approval has already been sought, because usually it costs the homeowner nothing or very little to get something approved by your ARB, or ARC in this case. So that's usually done first. Homeowner gets all their ducks in a row done first before they actually have to write a check out and come before us for approval. So my question to you is, why did you come before us and submit your application to us without having the approval of your homeowners association first?
Right. So we have submitted several requests. They were denied, and no reason was given other than the setback. So we figured we would get the setback corrected through the variance, and then go back and get approval. But I imagine they wouldn't give pre-approval pending the approval of the setback. So the denials have been, from what we've heard, because the setback is, because the fence that we're requesting is outside the setback allowance right now. So that's what I've been told. I don't know if the letter says otherwise, but.
Well, as Mr. Hadaway said about 10 minutes ago in relation to another application, your HOA is allowed to have setback requirements that are more stringent than that of the county. They can't have looser requirements than us, but they can have more stringent. So just because you may be granted a variance by us tonight, it doesn't mean that the HOA can no longer touch you because you have the variance from us.
Right.
You are aware of that, right?
Yes.
Okay. So
From my understanding, at least from what I've read with the HOA rules, I don't believe there's any setback in those rules. I'm just trying to go with, when I see setback in the email, go through the county, so.
thank you.
You have no requirement to get HOA approval before you come to us. He's just saying it saves you some money, but now that you're standing here, you spent the money.
Yeah.
That's why
Good, better,
HOA is usually
different.
done first.
Right.
I'm sure we're not into refunds, so.
That's fine.
Okay. Any other questions for the applicant? All right, thank you. Is there anyone to speak in support of the request? Is there anyone to speak in opposition to the request? Down.
Hi, good evening. Colleen Krigger, 5769 Autumn Chase Circle, Sanford, Florida. I do sit on the Architectural Review Committee. You all did receive Hillary's been wonderful, I have to say, in communicating when I had questions. She let me know that she sent you all the information. I apologize for so much information, but I think it was important to show how much we've gone back and forth with these homeowners regarding the fence. I won't go through all the statutes and the corner lots being called front yards. You all know all that stuff. And, you know, with our bylaws, we state that the fence is connected to the rear corner of the home. In this case, that would be here or here. This fence is currently 17 feet from the sidewalk. Their house is 19 and a half feet from the sidewalk. So if they were to align with their backyard neighbor, Beth Wilds, that would be ideal, but it really only gives them 2.5 feet outside of this open patio. So we met with Alyssa, another board member, and I myself met with her on property, and we said we would allow it to come 4 feet out just to give a little bit more space, and then that would keep the 15 feet from the sidewalk, which is your minimum variance, allowable 15 feet. And this tree is 7 feet from the face of this fence. So that would allow the fence to come out a couple feet from the existing fence and then go straight. Their proposal right now is to come out the 4 feet, come over here, and then come out another, and no other side. This is the last house in the neighborhood to have a corner lot fence. All of them are straight, continuous. They don't bump out around anything. From an aesthetic standpoint, I don't feel it's a good look. They didn't ask the neighbors directly across the street that would see it. They asked Ms. Wilds, who's behind them, that doesn't see that. With respect to the trees, that was something specifically we talked with Alyssa about. There's a hose bib here. There's one tree here. The main shutoff valve for the water is right here. We said we would allow it to go 12 feet from the back corner of the home. That leaves this vegetation outside of that fence, so that's a moot point as far as maintenance goes. They have one plant in there. So we're just asking that, we understand, we're trying to be understanding of not having that space outside of the patio. We also allowed, said that we would allow the gate to be on the south-facing fence instead of being, at the front of the house, because it would only be coming out 4 feet. And we keep getting, I can show you, I listed it in the email, the 5 iterations of, they want 2 feet from the sidewalk, we say no, they come back with 2 feet again, we say no, they come back with 5.5 feet, we say no, they come back with 10 feet, and we say no. So I think they're tired of being told no, so they came to you. So we're just asking that you deny it. We're totally fine with a compromise in allowing the 15 feet, because that's what your ordinances allow, 25 down to 15, but we're not, we kindly request that you deny the 10-foot variance request.
So to be clear, you would be okay if we modified it to 15 feet instead of 10?
Yes. And that's what we've said all along. We wanted to come 4 feet from the house, which leaves 15 feet to the sidewalk, or 15.5 feet to the sidewalk.
Well, it's from the property line. It may happen to be on the sidewalk.
Correct.
It's not always, but.
Right. Assuming it is.
Right. Okay. Any questions? All right, thank you.
Thank you.
Is there anyone else to speak in opposition to the request? Do we have a motion?
Wait.
Oh, I'm sorry, I missed you.
Doesn't he have to fill out the paper?
Maybe clerk already has it, I don't know.
Yes,
State your
name and address?
My name is Bill Campbell. I'm at 1600 Willow Oak Lane in Sanford. They're adjacent to that property. I'm also on the board. All that we really ask is, we're trying to, I live in the neighborhood and I want everybody to get along in the neighborhood. But all we're really asking is that the fence stay in compliance with all the other fences in the neighborhood so that we can all, benefit from property values. I mean, we don't need a fence like that when every other fence for 130-something houses is straight as an arrow and coming off at exactly the same angles.
Okay, so I'm going to ask you the same question.
Yes,
Would you be okay with a 15-foot setback as opposed to a 10?
Yes, I would agree with Colleen completely. I mean, we've tried to, the ARC has tried to come up with compromises so that they can have their fence and that everybody else can have their aesthetics. I mean, it's a deed-restricted community, so.
I got you.
But that's all I have. Thank you.
All right, thank you. Is there anybody else to speak in opposition to the request? Okay, now do we have a motion?
Yes, Mr. Chair. I would like to move to approve a modified version of the application at the 15-foot compromise distance proposed by the ARC.
So you making a motion to approve the request at 15 feet instead of 10 feet?
Yes, and at that point, the homeowner and the homeowners association can fight their battle after that.
Okay.
And what happens, happens.
Do we have a second?
Second.
Okay, any discussion?
Yes. Well, if we're ready to vote, go ahead.
All right.
Yeah.
I was just only comment I make, just a good compromise leaves nobody happy.
No.
And I kind of feel like we're there.
I don't know, they seem pretty happy by 15. But the association's paperwork, they really did their homework and gave it to us, that 15 feet is the most they've ever given any other homeowner in this subdivision on a corner lot, and that would not be out of character.
So that falls under, they won't be, she would be granted something otherwise that everybody else is not getting.
Exactly.
I got you. Okay. All in favor of the motion, say aye. Aye.
Aye.
All opposed? Motion carries. It's approved, ma'am, but at 15 feet, not 10 feet. Okay? If you do not like the decision, you have 15 days to appeal it to the Board of County Commission, and the staff can assist you with that. All right? Next item is minutes. We had an issue with the email. Not everybody got the attachment of the minutes, so we'll have them next month. All right, anything else for the good of the order? All right, y'all have a good night. We're adjourned. 9:03.